Please, Lordship. I beg to mention item number 4 and 5. Here, the man leading counsel is out of the station. So kindly adjourn the matter for today and fix it for 4th August.
What is your name?
P. Harming.
Counsel Mr. P.
Harming.
Harving. On behalf of Learned Counsel,
N. Kumar. Navin Kumar. It is reflected in the cost list, my Lordship.
4 and 5, no?
Yes.
Navin Kumar.
Yes.
It's not in that person.
And last, sorry, my Lord, in Wakalatama, sorry.
Okay, no, N. Kumar, no?
Yes.
On behalf of Learned Counsel, Mr. N. Kumar has prayed for adjournment. It is submitted that Wakalat Nama has been submitted by Learned Counsel, Mr. N. Kumar. Learned AG, no? But here it is written as DSGI. Oh, okay, okay. GA, it is written as GA. Learned AG, Mr. I. Chaudhary is present. List the matter of what?
4th August.
4th August. 4 and 5, no?
Yes, my Lord.
4th August.
Deeply obliged.
No.
What's this date?
Lordship, item number 3. This is
Just a moment, let me check if it is on
Tuesday.
if it is on be having DB day, no? It will if I fix it on a DB day. Yes,
Fourth is a DVD.
Okay.
Wait.
Yes. So today is not a DB day, but it has been fixed.
Lordship, item number 3. This is already released matter from this bench, Lordship. Item number 3, Lordship.
Item number 3
Yes, Lordship. The matter was released from this honorable court, Lordship.
from
From this bench, Lordship. From your bench, Lordship. Matter was taken on 18 November 2025. At that time, Lordship.
18 November 25.
Yes, Lordship.
Your Lordships had heard it at some length and after that released it, my lord.
Okay, okay.
So
Both of us have heard it.
exactly the same bench.
Same bench.
Yes, Lordship.
So, okay.
This also may be fixed on 4th, man.
4th, okay.
Lordship.
Parties are represented. List the matter on 4th August.
Lordship. Obliged. Thank you.
Number 3, no?
Item number 1 and 2.
May I please your Lordship? This matter has come for admission on the last opinion. Matter was heard, my lord, to some extent. And my lord, matter released to my lord, non-payment of area salary which accrued under 5th and 6th CPC. The honorable single judge rejected our prayer on the basic, my lord, findings that the entire area salary was paid. And on the last occasion, my lord, also the submission was made by my lord, Learned Advocate General, that payment was made. Therefore, nothing is left out. The proportion does not have to make any payments. And in support of this argument, Advocate General referred to 2009 notification, and court has also referred to 2009 notification. And whether on the basis of 2009 notification, my lord, can there be any possibility to arrive at a conclusion that payment was made? 2009 notification simply referred pre-revised pay scale and revised pay scale. There is no any indication or reference regarding payment of actual payment of my lord area salary. Therefore, my lord, we have challenged this decision of the honorable single judge by preferring this writ appeal. There are two connected writ appeal. And my lord, Learned Advocate General, my lord, on all occasions, my lord, submitted the my lord argument, made the submission that my lord, appeals are not at all admissible. And at the threshold, court should, my lord, reject the appeal. Now the question is, my lord, whether the decision of the honorable single judge is on merit or is on preliminary question of materiality of the writ petition. If it is a dismissal of the writ petition on the question of, my lord, materiality of the writ petition, question doesn't arise to hear the appeal on merit. But if the writ petition is dismissed on merit, then my lord, appellate court has got the jurisdiction to hear the matter on merit. Therefore, my lord, I would like to, my lord, submit the appeal on merit. An entire endeavor that was made by my lord Lord Advocate General is that appeal is not at all maintainable. It requires, my lord, in demand dismissal. And whether the court is otherwise, my lord, competent to hear the matter on merit once the writ petition was heard on merit. If the lordship is of the view that, yes, merit has to be heard, court requires judicial interference, then, my lord, argument will be made on merit, my lord. And once they have raised a question that, my lord, appeal is not maintainable and question does not have to hear the matter on merit, then they are to, my lord, address the court by raising a question of preliminary, my lord, question regarding maintainment to a writ petition, and writ petition cannot be heard on merit. Therefore, if my learned friend, my lord, address the court on the question of maintainability of the writ appeal, then I will, my lord, reply. Or if he doesn't, my lord, if he wants to, my lord, argue the matter on merit, then I will start my argument. On last 2-3 occasions, all along, my learned friend, my lord, made this submission that appeal is not maintainable on merit.
Okay,
Why
then
the
you
appeal is
start
not
your-
maintainable? Yes.
Okay, the other side will start that on
Yes.
maintainability.
On maintainability. Because there is the question,
Then-
appeal is not maintainable.
Then you are preferring to reply on his submission.
Yes.
All right then.
My lord, it's a very interesting case. What had happened was they claimed some arrear salary. And while claiming arrear salary, there were, when we filed our affidavit, we raised certain questions on maintainability. The learned single judge has dealt with those issues on maintainability and held that although there is force in the arguments on maintainability, the learned single judge proceeded to decide the matter on the merits of the case. Now, when they preferred the appeal, they have again resorted to serious suppression of relevant and material facts. On that issue, I am raising the question of maintainability. If your lordship will just allow me to place the relevant portion of the judgment for a moment. If your lordship will kindly come to the judgment. It starts at page 586. Page 586. It starts. And the issue of maintainability has been dealt with by the learned single judge at page 602. If your lordship will kindly turn to page 602, relevant paragraph is paragraph 36. May I read it? Admittedly, the challenge made pertains to minutes of Arunachal Teachers Association meeting dated 21/9/2011. Second, recommendation of the High Power Committee dated 12/9/2012, order dated 15/2/2013, and the speaking order dated 4/10/2014. However, having considered that some of the petitioners have approached the court in the year 2014 by filing WPC number 463 of 2014, although same was dismissed on withdrawal, liberty was granted to file afresh, and accordingly the present writ petition being WPC number 151 of 2018 has been filed. I am of the view that there is no delay and laches as such. The present writ petitions are not barred by delay and laches. Next is important. Having regard to the plea of writ petitions having been hid by principles of estoppel and waiver, I am persuaded to hold that there is some force to certain extent, as the petitioners in both the writ petitions are admittedly members of Arunachal Teachers Association, which had renounced the claim so made in the present writ petitions. However, having considered the nature of the claim, I am of the view that petitioners cannot be non-suited only on the above principles and thus inclined to consider on merits of the matter as the said plea would be considered with the merit so and so. So although the learned single judge found force in my argument on the points of waiver and estoppel, the learned single judge proceeded to decide on merit. However, now when they file the writ appeal, they resort to further mischief. How I'll point out. Their entire claim is just a few documents will show. And these are the documents, most relevant documents, which have been suppressed by the appellants even in the writ appeal. Because these documents form the very foundation of the decision rendered by the learned single judge on merits. Your Lordship will kindly take up our affidavit. We have filed an affidavit in the writ appeal because all these documents were suppressed by them. The state has filed an affidavit in opposition.
Oh, yes, sir.
Your Lordship will first come to page 622. This is a notification by which the Government of India,
How much? Wait,
page 622
in affidavit.
in the affidavit. It starts at, the affidavit starts at 608.
Okay. All right. 622.
This is a notification by the Government of India by which the benefits of the 5th Central Pay Commission were notified. Your Lordship will just make a note of two things, Madam. First, at page 622, your Lordship will find clause 1, subclause 2. They shall be deemed to have come into force on the first day of January 1996. So the effect of the 5th CPC was given from 1st January 1996. Now, what is the benefit that was given? So far as the petitioners here are concerned, your Lordship will find at page 631. Page 631, we are concerned with serial numbers 8, 9, and 10. So these are teachers who fall in these.
8, 9, and 10.
Yes, sir. So S8, S9, and S10 are the grades in which these teachers fall. Your Lordship will kindly see at column number 3.
Not S6, no?
No, S8, S9, and S10.
S8, S9, S10. Yes, okay.
Your Lordship will find at the top the heading present scale. So they were getting this scale. S8, 1350 to 2300. S9, 1400 to 2660. S10, 1640 to 2900. And the 5th CPC revision is in the right side now. Your Lordship will find, your Lordship will kindly make a note of these scales. 4500, 125, 7000. Then S9, 6000, 150, 8000. Then S10, 5500, 175, 9000. Your Lordship will kindly make a note of these revised scales.
Yes, yes.
So this is the benefit that was conferred by the central government to its employees. Now, the state government, we adopted this. At page 633, your Lordship will find that this central 5th CPC was adopted by the government of Arunachal Pradesh, and the benefit was also given from 1196. That notification your lordship will find at page 633.
Yes.
Your lordship will kindly note the date, madam. This date has a relevance. 9th of October 1997, it is notified. And this benefit is given with effect from 1196 to all these teachers.
There was a PPA complaint, I remember well,
Yes.
because I also got 98.
That is one sad part for us lawyers, my lord. We don't get any revisions. This benefit from 1997 with effect from 1196, they get. And since they get, there is no, your lordship will not find any petitions being filed, any objections being raised. What happened is this, my lord. If your lordship will kindly come to page 649.
Yes.
The lordship will kindly note the date of this letter, 4/4/2002. So what the government of India decided to do is to confer some additional benefit to employees serving in the union territories. Your lordship will kindly note that this is marked, this letter is marked, number 1, Andaman and Nicobar Islands, Port Blair. Number 2 is Dadra and Nagar Haveli. Number 3 is Daman and Diu. Number 4 is New Delhi. Number 5 is Lakshadweep. And number 6 is Pondicherry. And your lordship will find a chart. And if your lordship compares this chart, this existing scale with this page 633 that I pointed out, if your lordship simultaneously takes up 633,
Again, no?
no, not 633, 631,
631.
your lordship will find
It is the state government adopting the.
633 is the adoption by the state government. 631 is the central government notification, the revision that I pointed out.
631, okay.
Your lordship will kindly have a look at the right-hand column, revised scale. So 4,500, 125, 7,000. Now, if your lordship will kindly turn back to 649, your lordship will find what they are saying is existing scale 4,500, 7,000. And on the right-hand side, there is a further revision. So far as this particular scale is concerned, there is no change. Then if your lordship comes back to 631 again, your lordship will find 5,000, 150, 8,000. And if your lordship comes back to page,
5,150, 8,000?
yes, one.
Which column?
Page 631, right-hand column. It looks like 6,000. It is not 6,000. It is actually 5,000.
Oh, 5,000,
Yeah.
158,000.
158,000.
Okay, okay, yes.
Now, if your lordship will kindly come to page 649 again, your lordship will find the existing is 5,000, 8,000. That has been slightly revised to 5,500, 9,000. Similar is the case with,
Senior scale, no?
yes, senior scale.
All right.
Then again, if your lordship comes back to page 631 once again, 5,500, 175, 9,000. Then again, if your lordship comes back to 649, your lordship will find that 5,500, 9,000 is revised to 6,500, 10,500. This additional revision is only meant for the union territories. What happened is, as soon as this is issued, these teachers who are appellants before your lordship, under a different banner called Arunachal something Teachers Association, they started demanding this scale, saying that give us this scale, which is actually not even meant for them. It is meant for union territories. There is a long round of agitations and whatnots. So ultimately, the government examined the matter and took a policy decision, which your lordship will find at page 650. Government took a very lenient view. Your Lordship is aware of the law. A recommendation of a pay commission. It is only a recommendation. The government may or may not accept it. But we took a lenient view, and although it is not meant for state governments, it is meant only for union territories. We said, all right, let us be lenient with these people and let us give them this additional benefit. And if your Lordship will kindly look at this page 650 at the top, we are concerned with table number 1. We gave them that additional benefit which was meant for union territories. And when we gave them, what we said was, if your Lordship will come to the paragraph below the tables, the scales of pay of aforesaid categories of employees will be notionally fixed from 5th CPC stage as adopted in the state with effect from 1/4/98 under relevant rules, orders, and actual financial benefits. However, will be tenable from 1/4/2013, i.e. pay and allowances from the month of April 2013 without arrears. They will enjoy the pay fixation benefits only. So what we said is, since we are giving you an additional benefit, which is not even meant for you, it is meant for union territory. So we are giving you the benefit, but not retrospectively. We will give it to you prospectively, and notionally we will fix it from an earlier date, from when 5th CPC was implemented. Now what they are asking for is, give us that, during that notional period, give us the arrears. How is it even tenable? What locus do they have? What legal right do they have? Your Lordship is aware of the law. When a citizen invokes Article 226 of the Constitution, the first question that your Lordship asks is, what is your legal right? Now, the reason I am raising a preliminary objection is, normally in a writ appeal, we are not even required to file any affidavits because all materials are before the learned single judge and everything is annexed. These documents are suppressed in the writ appeal. And these are the documents that form the very foundation of the case. If your Lordship now in this context peruses the judgment of the learned single judge on merit, your Lordship will find so at paragraph 36, page 602, the learned single judge deals with the maintainability issue. And from paragraph 37 onwards, the learned single judge goes into the records and they file a writ appeal of this size. For a person like me, it is not even possible to carry it. That is how heavy it is. But they forget to, either deliberately or otherwise, they forget to annex the most important documents. Your Lordship will kindly come to page 602, paragraph 37 onwards. This is how the learned single judge dealt with. Undisputedly, the learned single judge starts with the word undisputedly. Undisputedly, the 5th Central Pay Commission recommendations came to be implemented by the Government of India by notification number so-and-so dated 39/97. Subsequently, the Government of Arunachal Pradesh implemented the 5th CPC notification number so-and-so dated 9/10/97. It was followed by another OM number so-and-so dated so-and-so, whereby it was clarified that revision of pay scales in respect of Government of Arunachal Pradesh, the party of the first schedule, would be applicable. Thus, as far as the aforesaid office memorandum dated 23/10/97, the pay scales as notified in Part B and Part C of the schedule would not be applicable to the government employees of Arunachal Pradesh. It is taken note that prior to implementation of the 5th CPC, the elementary teachers were drawing a pay scale of 1350, etc., 2300. Their pay scale was revised under the 5th CPC, and accordingly, elementary teachers were paid at the pay scale of rupees 4,500 to 7,000 entry scale. The senior scale was revised to S9, and they were revised to the pay scale of so-and-so, and selection scale was revised to S10 and revised to pay scale of 5,500, 9,000. It is seen that the state respondents have clarified the implementation of the first schedule party of the 5th CPC. Having considered the office memorandum dated so-and-so, issued by the government of Arunachal Pradesh, implementing recommendation of the 5th CPC in the state of Arunachal Pradesh in respect of Part A of first schedule, I am of the view that no arrear salary is pending in respect of primary elementary teachers against the recommendation of 5th CPC. This is a final finding and conclusion. Record reveals that after implementation of the 5th CPC, the government of Arunachal Pradesh had also implemented the recommendation of the 6th CPC, filed OM number so-and-so dated 5/1/2009. Accordingly, the pay scale of primary elementary teachers under the Education Department, Government of Arunachal Pradesh, was again revised as per the 6th CPC and ordered for implementation of Part B pay scale under the 6th CPC for teachers serving under Government of Arunachal Pradesh, corresponding to the 5th Pay Commission, with effect from 1/1/2006 by the order number so-and-so dated 8/9/2009. It is noticed that all the teachers serving under Education Department, Government of Arunachal Pradesh, including petitioners, have received the revised pay scale under the 6th CPC as notified by the Education Department. Perusal of the record reveals that the Arunachal Teachers Association, under which the petitioners herein are also the members, has demanded revision and enhancement of their pay scale as per Government of India letter number so-and-so dated 4/4/2002, after having received revised pay scale as per 5th CPC and 6th CPC. Perusal of the above letter dated 4/4/2002 issued by the Government of India clearly shows that the same was meant for union territories mentioned therein. Thus, it would not be applicable to the state of Arunachal Pradesh. However, in response to such demand of the said Arunachal Teachers Association, it appears that the Government of Arunachal Pradesh has decided to accept the request of the said association. Accordingly, pay scale of elementary teachers serving under the Education Department, Government of Arunachal Pradesh, was revised and refixed by order number so-and-so dated so-and-so issued by the Commission on Education, the Government of Arunachal Pradesh, as per the revised pay scale fixed by the Government of India by letter dated 4/4/2002. Although such pay scale was specifically meant for employees of Union Territories, Government of India, and not for Government of Arunachal Pradesh. Bare perusal of the order dated 15/2/2013 makes it clear that the concerned teachers, including the petitioners, were already enjoying the benefit of the 5th CPC recommendation. And what was granted by the said order was an additional benefit in terms of the Government of India letter dated 4/4/2002. It is also seen that in order to pay the primary elementary teachers, including the petitioners serving under the Education Department, Government of Arunachal Pradesh, higher pay scale as per the Government of India letter dated 4/4/2002, the revised pay scale by order dated 15/2/2013 was notionally fixed with effect from 1/4/98 to 31/3/2013, and actual benefit of the revision was granted with effect from 1/4/2013. Accordingly, all the teachers represented by the Arunachal Teachers Association had accepted the revised pay scale as notified by the Education Department and have received their pay scale. Thus, the primary elementary teachers, including the petitioners serving under Education Department, Government of Arunachal Pradesh, have received their revised pay scale under the 5th and 6th CPC. Regard being had to the main thrust of submission as strenuously urged by the learned counsel for the petitioners, to the effect that the respondent authorities have admitted the claim of the petitioners in the earlier affidavit and cannot turn around and denied the same by filing fresh affidavit, on having considered the categorical stand of the state respondents that the nodal officer, the office of the Directorate of Elementary Education, namely Sri Bamar Inyao, who is also an interested party in the aforesaid writ petition, and the then Director of Elementary Education, Sri so-and-so, had filed false affidavits dated so-and-so and additional affidavit dated so-and-so, whereby the claim of the petitioners was falsely admitted by misrepresentation of the factual aspects of the case without the knowledge and approval of the competent authority of the Education Department at the government level. And upon having detected such serious misconduct committed by the aforesaid two officers, the Government of Arunachal Pradesh had placed them under suspension and disciplinary proceedings have been initiated against them. This court is not persuaded to take a view that the claim of the petitioners has been admitted, but constrained to observe that such action initiated against be brought to its logical conclusion. To pause here for a moment, what had happened when the writ petitions were filed, there were two interested parties who,
teachers.
yeah, they, without informing the government, they filed two affidavits totally false affidavits admitting the claim of the petitioners. When it came to the notice of the government that these false claims have been admitted, we took the permission of this honorable court and we filed a fresh affidavit putting on record the actual situation, as I have just argued. That this is a benefit, it is an additional benefit. They have already received their benefits under the 5th CPC. That is why your lordship will kindly note, from 1997, when the benefit was given 5th CPC, there was no writ petition filed till 2014. For the first time they filed the writ petition in 2014, when we issued the notification of 2013 granting them the benefit, additional benefit. They said that no, not notionally. We want actual benefit from 1990. We said, we are giving you an additional benefit by taking a very liberal, lenient view. How can you claim it as a matter of right? And all these things were falsely admitted by filing affidavits. When the government came to know, we filed a fresh affidavit pointing out the correct picture. And to proceed further, man, I have perused the case laws relied on by the learned counsel for the parties. On careful reading of the said judgments, I find that the decisions rendered are on its facts and circumstances of those cases are settled principles, which in any manner do not come to the aid of the petitioners, as the claim of the petitioners is totally different in the present case. Perusal of various other decisions of the Honorable Supreme Court clearly shows that the recommendations of the Pay Commission are not binding upon the state governments, and the state governments may or may not accept the Pay Commission's recommendation. The Honorable Supreme Court has also held that the court, while exercising judicial review, should not interfere with the policy decisions having financial implication on the state. In the present case, as noted herein above, in order to pay a higher pay scale to the teachers, including the petitioners serving under the Education Department, Government of Arunachal Pradesh, as per the Government of India letter dated 4/4/2002, the revised pay scale wide order dated 15/2/2013 was notionally fixed with effect from 1/4/1998 to 31/3/2013, and actual benefit of the revision was granted with effect from 1/4/2013. All the teachers, including the petitioners represented by the Arunachal Teachers Association, had accepted the revised pay scale as notified by the Education Department by order number so-and-so dated 15/2/2013, and had accepted and received their pay scale. The teachers, including the petitioners serving under Education Department, Government of Arunachal Pradesh, have already received their revised pay scale under the 5th CPC and the 6th CPC. Thus, the petitioners are barred from claiming arrear salary with effect from 1/4/98 to 31/3/2013. In view of what has been discussed herein above and in the facts and circumstances of the present case, this court is of the considered view that the claim of the petitioners for payment of arrear salary with effect from 1/4/98 to 31/3/2013 is unjustified, and they are not entitled for arrear salary with effect from 1/4/98 to 31/3/2013. So therefore, my lord, not to speak of the merits of the case, my first objection is, as your lordships always insist, that when you approach a writ court, you have to come with clean hands. When you know that the foundation of the case is dependent on a few basic documents, it is your duty to annex those documents and bring it to the notice of this honorable court. So my first objection is this writ appeal should be dismissed with exemplary cost. I will just point out, your lordship may make a note, what are the important documents that they have suppressed. First document they have suppressed is the Government of India notification dated 30/9/97, by which the 5th CPC, benefits of 5th CPC was notified. 30/09/1997. 30/09/1997. Why it is relevant is, it shows what was the pay scale under the 4th CPC and what is the revised scale under the 5th CPC. That is one document that has been suppressed. Then the second document that has been suppressed is Government of Arunachal Pradesh notification dated 9/10/1997, by which the Government of Arunachal Pradesh had adopted the 5th Central Pay Commission. This has been suppressed. Next document that has been suppressed is, we have not only given the benefit of 5th CPC, we have also given the benefit of 6th CPC. much before that 2013 notification. That is 5/1/2009. This is the government of Arunachal Pradesh notification by which the 6th CPC was adopted by the government.
5/9/2009.
5/9/2009. Now, the most vital document that has been suppressed is that document which is meant for union territories. That 4/4/2002. 4/4/2002 Government of India's notification, which makes it clear that the benefit is meant only for union territories, not for the states. So these are the vital documents that have been withheld from this honorable court, and the motive is clear. They wanted to mislead this honorable court into passing an order in their favor. So therefore, my lord, my respectful submission before your lordship is that this writ appeal should be on this ground alone. It should not only be dismissed, it should be dismissed with exemplary cause. Your lordship will not allow such conduct in a writ court. This is a court exercising extraordinary jurisdiction. Your lordship is aware, I am not troubling your lordship with those judgments. In the case of K.D. Sharma, I can give the citation. 2008-12 SCC, I think. K.D. Sharma judgment, the Honorable Supreme Court went to the extent of saying that if you do not come with clean hands, not only costs should be imposed, contempt should be drawn up against these people. You cannot play hide and seek with a court exercising extraordinary jurisdiction. You cannot make these serious attempts at misleading. And on the merits of the case, as I was pointing out, had they had any grievance regarding 5th CPC, from 1997 till 2014, the fact that they did not approach this honorable court itself goes to show that they never had any grievance with regard to 5th CPC. It is only the additional benefit meant for union territories that they claimed, and we became benevolent, we became lenient, we became liberal, and we granted that additional benefit. While granting the additional benefit, we said that we will give it to you prospectively. We won't give it to you retrospectively. We are giving it to you notionally. Your lordship will just imagine the burden. If we have to give this benefit, which is not even meant for them, from 98 to 2013, if we have to give this benefit, it will be hundreds of crores. It is taxpayers' money. This money is not growing in trees that we can simply pluck it and give it to them. Oh. Therefore, my lord, all along their conduct has not been bona fide, and in any case, they have not been able to establish any legal right whatsoever. And therefore, my lord, in my respectful submission, the learned single judge has rightly dismissed. In fact, the learned single judge took a lenient view that on maintainability, in spite of recording a finding that there is force in the arguments on maintainability, did not dismiss it on maintainability. The learned single judge still proceeded to decide on merits. So therefore, my lord, looked at from any angle, I am not troubling your lordship with judgments. There are several judgments of the Supreme Court which says that recommendations of the pay commission are not binding on the government. If needed, after my learned friend makes his submissions, if needed, I'll place those judgments. But that's all.
May I please the lord? My lord, number of harsh words, number of, my lord, embarrassing statements were made. But the basic question, my lord, that was absolutely left out by honest Advocate General. What is our claim? We never disputed the, my lord, revised Pascal or pre-revised Pascal. We approved the code, making a simple prayer in 2014 that you introduced, you adopted the 5th and 6th CPC because you don't have any state pay commission. All along you adopted central pay commission. Therefore, we are entitled to, my lord, get some arrears salary because you have given retrospective effort. You have implemented the, my lord, fifth CPC and sixth CPC with retrospective effect. Therefore, whatever amount accrued in view of retrospective implementation, we are entitled. And secondly, my lord, whatever documents he referred, my senior friend referred, my learned friend referred, these are not at
I'm
all
sorry.
relevant.
Just
Not
one.
at
sorry
all
to-
relevant.
Can I come back in 5 minutes? I have to
Yes.
attend to something
yes.
urgent.
Therefore, these documents are not at all relevant. We never made any claim on the basis of central government notification. He referred 2004. Connection with that?
Yes.
Yes.
Please
Just
read.
central government notification is made applicable to Union territories. That notification was never relied upon by us. We did never rely upon this notification. We never claim any, my lord, area salary on the basis of that document. Therefore, question doesn't arise. On the other hand, my lord, our simple case is that there is some area accrued in view of implementation of the fifth and sixth CPC. You better consider our prayer. Then, my lord, initially, my lord, they appointed 3 members, my lord, committee that was constituted by the department itself. My lord, the Director of Elementary Education General, Director of Elementary Education Administration, and Director of Elementary Education, they were the members, and they, my lord, submitted a report. We have annexed this report as my lord, Annexure 1 of our writ petition. This committee recommended that the claim of the petitioner for area salary is genuine. And they arrived at the conclusion that at best they are entitled to receive 5,64,000. They made a calculation. That report was submitted before the government. Then government may not constitute a high power committee.
Those 3-member committee, the two of them have been suspended, no?
Who, my lord?
The 3-member committee.
No, nodal officer, my lord, they made an allegation against the nodal officer and director that this, my lord, affidavits are filed collusively. But I will come later on, my lord. So, my lord, whatever committee was constituted by them, committee submitted the report in our favor, holding that the, my lord, claim of the petition for area salary is genuine. And they recommended 5,64,000, my lord, before the government. Report was sent to government. Then government constituted 3 members, my lord, a high power committee. High power committee submitted the report by examining everything in details. They said that area salary be released on installment basis, phase by phase. Therefore, at that point of time, they never raised a question, my lord, we are not entitled, or my lord, our claim is absolutely bogus claim. They rather, my lord, entertain our claim. Committee was constituted. It is your committee. Committee submitted the report in our favor. Then, my lord, they did not act upon this report. Then ultimately, my lord, in 2013, they issued this notification. Now they are trying to project that 15/2/2013 notification is nothing but a policy decision. In normal parlance, my lord, we understand what is policy decision. There must have some notification. There must have some, my lord, factual background to frame a policy decision. They are supposed to issue notification. Now they are trying to say that 15/2/2013, it is impugn order, my lord, notification is a policy decision. And by, my lord, issuing that notification, they say that you are entitled to, my lord, only notional benefit without any monetary benefit, notional revision benefit without any area benefit. Then, my lord, during that period, there was a negotiation taken place between, my lord, teachers association. And teacher association, my lord, they took a resolution, they submitted their resolution before the government. They were ready to relinquish first part because our claim was under, my lord, both the my lord, CPC, 5th CPC and 6th CPC. 5th CPC is with effect from 1/4/98 to 31st, my lord, December 2005. And 6th CPC is 1/1/2006 to 31st March 2013. They are ready to relinquish the first part. They did not relinquish, my lord, the entire period, both the CPC. Then, my lord, in affidavit, first affidavit they have filed in connection with the writ petition. In that affidavit, they said ATA relinquished the entire claim. At that point of time, they did never raise any question of, my lord, separation of material facts. They did never raise any question regarding policy decision, etc., etc. They say that whatever relief you claim, that was relinquished by your parent organization.
No, just a moment, no. They are not raising question of separation of facts in the WPC. They are raising the separation of facts in this case, in this appeals.
No. Ultimately, my lord, when they filed the, my lord, two affidavit on the basis of decision of law department, had annexed, my lord, I in their affidavit. They said that since the decision was taken by the government accepting the claim of the petition to be genuine, therefore we are not going to controvert. Then they filed two affidavits, and both the affidavit they admitted our claim. They made a request to court. There is a lapse on the part of the government advocates, so they tendered unconditional apology. Then all on a sudden, my lord, they filed my lord, last affidavit without taking any leave of the court. They withdrew the earlier affidavit. They said we are going to discard the earlier affidavit, and therefore we want to file the fresh affidavit. In that affidavit, there is all this allegation. Therefore, initially, my lord, they did never raise any question regarding separation of material facts. What sort of separation? The documents which are not relied upon by the petitioner, does it require for the petitioner to bring on record those documents? We are not relying on that. These documents have nothing to do with us. We never made any claim on the basis of central government notification. We said once you have accepted CPC with a retrospective effect, we are entitled. Whether we are entitled or not entitled, this is the question to be dealt with. What is the question to rely on certain documents which are not at all applicable to us? Why should you submit these documents? They, for the first time in their affidavit, which they have filed on 13/9/2023, after filing of two affidavits dated 18/10/2022 and 16/5/2023, in those two documents affidavit, they come to a positive conclusion. My lord, tendering an apology before the court, there was a lapse on the part of the government. Already government has taken a decision. Therefore, with reference to Annexure I, my lord, kindly come to the conclusion, my lord, kindly come to that portion of the affidavit, my lord. I'm referring to, my lord. My lord, you may come to page 409. Read appeal 409, appeal memo, my lord, 409, Annexure I, which is the, my lord, documents they, my lord, enclosed. And on the basis of this, my lord, documents, they admitted our claim by filing two affidavits. Have you also got, my lord?
Yes.
409.
Yes, 409.
Annexure I. May I read, my lord?
Yes.
My junior will, my lord.
The draft para-wise reply as attempted by the department in the writ petition number 151 AP18, Sri Najuminyo and others versus State of Arunachal Pradesh and others, filed in the Guwahati High Court with another permanent bench regarding and grant of payment of arrear salary amounting to rupees 5,64,000 for the period from 1/4/98 to 31/7/13 to the petitioners who are regular employees working in the education department as teachers and librarians in various schools of elementary education has been seen with reference to the abatement in the above writ petition, and the abatement appeared appropriate. Department is now advised to pay the same and file the affidavit in opposition in consultation with the senior government advocate and submit the same before the Honorable High Court, Itanagar Permanent Bench, Naharlagan in time.
These documents were all in courts. When the matter was pending before the court, we came to know that government has already taken a decision. Then we applied for, my lord, under RTI, and they supplied these documents. Now, our lordship, kindly come to, my lord, have a look, my lord. All competent authorities, they put their signature, countersign. And on the basis of this, my lord, decision of the government, this is the decision of the law department. This is not the decision of the, my lord, education department, highest authority. They granted, my lord, approval. And on the basis of this approval, ultimately government filed two affidavits. They said there is a lapse on our part. We are not aware of this decision. Subsequently, we came to know. So we tender unconditional apologies because of lapse on our part to bring it on record. And ultimately, court, my lord, issued an order on 3/5/2023, directing the Standing Council to place on record the latest stand of the government. When the matter was referred to my lord commissioner, new commissioner, he joined in March 2023, they filed the my lord subsequent affidavit. Therefore, my lord, question I want to raise, once you have admitted by filing 2 affidavits on oath, without the leave of the, can you withdraw these documents suo motu? And making all these allegations, suppression of material facts, my lord, allegation, collusive submission of affidavit? Oh, yes. And my lord, kindly see,
Yes,
they say they did not have the knowledge. Whole contention basis of filing the fresh affidavit, my lord, in the event of withdrawal of the earlier affidavits, they said that affidavit was filed without our knowledge. Affidavit was filed without the, my lord, approval of the competent authorities. Now, my lord, to negate this, my lord, statement, to negate the contention, I would like to, my lord, refer to a particular letter, my lord, which is a part of record. Lord, kindly see. They said they did not have the knowledge. It's not going to go. Lord, kindly come to page 474. 474. This statement is, my lord, in reply to the contention made that the affidavit was filed without their knowledge and no, just a minute, my lord, just
Page, which page?
yeah.
Which page?
508.
Huh? Page 474.
508. 508.
Yes.
Yes. I'm just reading, my lord. In reply to the contention that 2 affidavits were filed collusively without the knowledge of the department, without the approval of the competent authority. Now, my lord, in order to negate this statement, I would like to, my lord, read this particular statement based on certain records. The deponent further states that once the present answering respondent filed 2 separate additional reply affidavit on behalf of all the respondents, including the finance department, in terms of office communication dated 2/2/2022. This is the communication. This communication was made by finance department to education department. Kindly file the affidavit in connection with the present petition. We are not going to file any separate affidavit, and you file a joint affidavit, and we will rely on that affidavit. Therefore, finance department communicated this letter to education department commissioner. How, on the basis of this notice, this letter, in ignorance of this letter, how can you say that the affidavit was filed without their knowledge? What is them and then fate of this matter statement made by them in their affidavit? This is the manner of communication. By this communication, finance department requested the education department has authority. Commissioner says he is the head of the authority, assuming that he is the head of the authority, and commissioner secretary is holding the same post. Then communication was made making a request, you file affidavit on behalf of the finance department. Accordingly, they filed the joint affidavit. Therefore, my lord, in view of this communication, what is the question, my lord? To make a statement that affidavit, 2 affidavit, that is 18/10/2022 and 16/5/2023, admitting our claim on the basis of, my lord, the annexure, my lord, annexure I. It is the decision of the law department, highest authority. They accorded approval. And therefore, these 2 affidavit was filed on the basis of this decision of the government. Now they are saying these affidavits are false because authority, competent authority, did not have any knowledge. Therefore, my lord, lordship may come to the conclusion, may, my lord, consider that there was a communication dated 2/2/2022, and by this communication, finance department already intimated education department filed joint affidavit. So how do you say you don't have the knowledge? And whatever affidavit was filed, that was filed on the strength of this communication. Therefore, this allegation is absolutely, my lord, absolutely miscom. This allegation is baseless, absurd, motivated, purposeful. And you are talking about the collusive submission of, my lord, 2 affidavits. You suspended the director, you suspended the nodal officer. And what action you have taken till date? They were instated in service. They are instated in service, my lord. Therefore, mere lordship knows, my lord, mere allegation cannot be the basis. And my lord, 3 days back, when the Supreme Court held that mere affair will not oust a government employee from service. It's a mere allegation. You brought certain misconduct, allegation of misconduct. What has prevented you to prove the, my lord, misconduct? Till date, my lord, nothing happened. They were instated in service. Therefore, this allegation is absolutely baseless, motivated only for the purpose of, my lord, to avoid their liability to pay. And what is the rule on our part, my lord? In decision-making process, that was decision was taken by commissioner on 2/2/2020, and thereafter they made the communication on 2/2/2022, and on the basis of this decision, ultimately they filed the affidavit. So what is the wrong, my lord? And what you are saying by referring, my lord, 2009, my lord, kindly see what is their stand in their affidavit. They said everything was paid. If everything is paid, court has also come to the conclusion there is no any outstanding, my lord, area salary. Everything was paid. What is the documents? This is a post-litis, my lord, factum statement. This statement does not have any basis. It is not admissible in evidence unless and until this statement is supported by a certain document. What has prevented the government to produce the record? Number of records could have been produced in support of the payment. Thousands of teachers, bank account, then money is supposed to be deposited in their account, then finance department ordered, treasury office ordered. Nothing could have been produced by them to show that, my lord, area salary was paid. Now they refer to, my lord, 2009. Lordship, you kindly come to 70. My lord, page 570 of the appeal memo.
Page
570 and action 15. Page 570.
570.
570. Have you lordship got, my lord?
yes, 570.
Yes. They relied heavily on this document. By referring to this document as well as, my lord, equally by the court, that everything was paid, nothing is outstanding. Whether these particular documents can show or shows anything positive regarding payment. This is a notification which, my lord, clearly reflects the pre-devised scale and revised pay scale. We don't have any, my lord, dispute. We never raise any question regarding this should be our pay scale, that should not be our pay scale. This is not our case. Our case is, my lord, whatever difference arises in between the revised pay scale and pre-revised pay scale, which is called area salary, we are entitled to that area salary. Now, on the basis of this particular document, can court come to the conclusion everything is paid? What is the question of payment of area salary on the basis of this document? There is no any whisper or reference regarding payment of area salary. Simply, my lord, it reflects the designation, my lord, pre-revised pay scale and pay scale. They said additional value. What is the question? Pardon, my lord? What is the question, my lord, to pay?
Please continue.
Where is the question, madam? Why is the question to receive the, my lord, area salary? Why is the question to payment of area salary on the basis of this document? Any layman will understand, my lord. And court has said everything is paid. We have never disputed our basic pay scale. What we are claiming, the area salary difference between pre-devised pay scale and revised pay scale. And lordship kindly say, then, my lord, I would like to, my lord, refer to one more, my lord, my lord, documents. Another affidavit. Alige position to para 4. Yes. But document which they relied on, that is annexure C. Annexure C. Just a minute.
Annexure C of the affidavit, no?
Yes, they're appealing in opposition. Filed in connection with writ appeal. They are referred to and they relied on these documents. Annexure D. Just a minute, madam. Yeah. Annexure B, madam. Sorry, madam. Absolutely sorry. Annexure B. This is the document they relied on 9th December 1997. Court has also referred to these documents. Kindly come to page 634, para 4. Does it, my lord, say anything regarding area 7? May I read, my lord? 634, Annexure B, the document which they relied on in their affidavit in opposition, filed in connection with writ appeal. May I read, my lord?
Yes, yes.
Yes.
Page 634.
Yes, please, my genuine read, my lord.
Your Lordship, para 4.
I want to show by referring to this particular paragraph that there is a provision for a payment of area salary.
Your Lordship, para 4. After fixation of pay on 1/1/96, each employee may be allowed to draw the difference of pay only between the pay fixed in the revised scale and the pay drawn in the pre-revised scale. This therefore follows that the quantum of the other allowances drawn on pre-revised scale as on 1/1/96 other than dearness allowances now merged with the revised pay scale will continue to be drawn by the employee till further order are received from the Government of India. The revised allowances other than dearness allowances will be effective from the 1st August 1997. The arrear would be paid in case with the stipulation that where the amount of arrear is less than rupees 5,000, it should be paid in one installment, and where it is excess of rupees 5,000, it should be paid in two installments. In the first installment, payment should be restricted to 5,000 plus 50% of the balance amount of arrear.
Therefore, my lord, there is a provision for payment of area salary that is in respect of 5th CPC. Of course, my lord, 5th CPC we are dwelling with. Even then, court has come to the conclusion that everything was paid pertaining to 5th CPC. Therefore, you are the government, you are the custodian of records, everything is in your custody. What has prevented you to produce records? At least to, my lord, inspire the confidence of the court that everything was paid. Whether mayor's statement is sufficient, somebody says, my lord, everything is paid. Now the question, my lord, if you say everything is paid, then, my lord, why did you, my lord, come with an order in, my lord, 2013 that you are not entitled to a arrear salary? Everything was paid to us. Then what is the question? Why did you, my lord, say nothing will be paid? You are referring to 2009 notification saying that everything was paid. Court said everything was paid. Court did not, my lord, look into the very, my lord, the recital of, my lord, 2013 notification. Notional benefit without area salary. You say 2009 everything is paid. Assuming that everything is paid, what has prevented you to produce the record, relevant records? Then we would have been the last man to withdraw the writ petition. Court, they raised a preliminary question, court did not accept. Whether court has considered or not considered, that will be reflected on the basis of findings of the court. They said court appreciated our preliminary objection, but court did not act upon their preliminary, my lord, objection. Court intended to decide the matter on merit. Can they come back and say, my lord, that question still survives unless and until there is an appeal preferred? And how appellate court, my lord, being a court of appeal, how appellate court can be prevented to look into the merit of the case? And where is the question of suppression? You raised question that affidavit was filed collusively. You did not raise any question, my lord, regarding the decision of the government, Annexure I, on the basis of which you admitted. Did not, my lord, utter a single word, no affidavit, nothing of this sort, my lord. And what rule we have got to, my lord, in the decision-making process? It is a decision, my lord, government itself has taken the decision. Did you have, my lord, any rule to play? Is there any scope for us to instigate the government, to persuade the government to come to this decision? What is our rule, my lord? Therefore, we, the innocent, my lord, teachers, we have been deprived of our legitimate dues. That apartment on the top of it, my lord, Annexure 1A and 1-2, Lord, kindly see of my appeal memo. These benefit, arrear salary was paid to other government departments. Deputy Commissioner Establishment and NUTS of the health service. They did not utter a single word. They did not even deny.
Page number 215.
215.
Appeal memo.
Appeal memo. These are the two documents, my lord, which show that arrear salary was paid to Education Department or Deputy Commissioner Establishment and the NUTS. They are Part B. We also belong to Part B.
250 or 215?
Yes. Now
215.
215.
215.
Yes, Lordship.
Annexure 1A. And 1B. These are the two documents we relied on in support of our contention that arrear benefit was given to at least two departments. What is your stand, my lord? Did they raise any objection? Did they, my lord, dispute this contention? Did they discard these two documents? Why should there be a discrimination? You are talking about policy decision, therefore judicial, my lord, review is not permissible. What is the question of, my lord, to construe the impugn order to be a policy decision? And who is the authority to frame the policy decision? Supreme Court says it is only the legislature or head of the state. Can department, my lord, frame any policy decision? To deprive them, my lord, legitimate dues, deprive them, my lord, teachers of their legitimate dues. And what is the procedure? They said consistently that pay revision is not binding on the government. Central CPC is not binding on the government. Central Pay Commission is not with the mere recommendation. In the form of recommendation, it has come to the government. It is for the government to take appropriate decision either to accept or not to accept. But once it is accepted by the government, adopted by the government by taking cabinet decision, can you deny it? And what is the question to constitute to be additional benefit? It is all legitimate dues. Whatever arrear salary or whatever device pay scale was prescribed by the central government, in the event of acceptance of this, my lord, pay commission recommendation, it has become law. Now I will come to, my lord, what is the law regarding this? They did not make any submission. They simply say it is not binding on the dam. It is 100% binding on law. Because ultimately it was converted into ROC rules, 2008. And whatever amount was recommended by the government by taking approval by law department, 5,64,000, that is the initial, my lord, calculation made by the departmental committee, by the Annexure A of the writ petition. Therefore, my lord, this recommendation is binding on the government in view of the provision provided under Arunachal Pradesh State of Arunachal Pradesh Act 1986. My lord, a copy will be, my lord, provided to my lord, by my junior. State of Arunachal Pradesh Act 1986. Can it be the absolute discretion or administrative wisdom of the government to deny, to say recommendation is not binding on them? Section 46. Have you lordship got, my lord?
Yes, yes.
Yes, Arunachal Pradesh, my lord. Background is that Arunachal Pradesh initially, my lord, a part of Assam, subsequently it was declared as Union Territory. And at the time of a Union Territory, my lord, all central government laws are made applicable. Subsequently, Arunachal Pradesh was declared as statehood, has given the statehood status. And in that, my lord, connection, the government enacted Arunachal Pradesh Act 1986. What is the consequence of all existing or enforced rules, regulations, statute of the central government? To overcome this situation, they incorporated section 46 in that particular act. I'm reading better. All laws in force immediately before the appointed day. Now, Lordship kindly says, what is the appointed day? Appointed day, as defined in section 2 of the act, is the date on which the gazette notification was issued, day on which the act came into force. As per section 2b, all laws in force immediately before the appointed day in the existing union territory of Arunachal Pradesh shall continue to be in force in the state of Arunachal Pradesh until altered, repealed, or amended by a competent legislature or other competent authority. Therefore, my lord, by incorporating this provision, they said all existed, my lord, existing rules, regulation, etc., my lord, applicable to Union territories will continue to be enforced. Now, subsection 2. For the purpose of facilitating the application in relation to state of Arunachal Pradesh of any law made before the appointed day, whatever law was made or existed prior to appointed day, the appropriate government may, within 2 years, Lordship kindly see, within 2 years from the date, by order, make such adaptation, modification of law, whether by way of repeal or amendment, as may be necessary or expedient, and thereupon every such law shall have effect subject to adaptation and modification so made until altered, repealed, or amended by a competent legislature. Competent legislature means cabinet or other competent authority. Competent legislature means legislature or cabinet decision or any other competent authority. Therefore, below, whatever law existed or enforced prior to appointed day, that will continue, but you have your wisdom or discretion to make necessary, my lord, amendment, to necessary modification. Did you make any, my lord, amendment? Rather, by taking a cabinet decision, you adopted the, my lord, 5th CPC and 6th CPC without any alteration. In paragraphs 15 of their affidavit in opposition, original affidavit in opposition, they admitted there was no any alteration, my lord. Therefore, whatever recommendation was accepted and adopted by the state government by taking a, my lord, cabinet decision, that is binding on them. Therefore, there is no any scope. Yes, I can understand, my lord, recommendation is not binding, provided there is some amendment.
Those were meant for the other union territories, not for Arunachal Pradesh. It's okay. Then it was specifically written Goa, Daman and Diu and so and so and so and so, not Arunachal Pradesh.
Which Uttudanto we are not relying on, my lord. I am referring 46. What is the relevant provision how to accept the central government rule, how to make the central government rules applicable in Arunachal Pradesh? Because pay commission is a central government, my lord, pay commission. If you want to adopt the pay commission, then you have to access power under section 46. I am not referring that particular notification. Therefore, my lord, once it is adopted, it is binding on you, unless there is some amendment. They said, my lord, no amendment took place at any point of time. Paragraph 15, my lord, kindly come to their affidavit, page 15, paragraph 15.
Page.
I am showing up. Their first affidavit.
Page.
I'm showing my lord, just a minute. Voluminous report, my lord. Page 312. Yes. 318. Whether there was any amendment made or alteration took place by accessing power on subsection 2 of section 46 of Arunachal Pradesh Act 1986. What is their statement? Because we made specific statement in our repetition that recommendation was accepted in toto in its entirety. And I will show one decision made pertaining to 2006. They made positive statement before the court. We adopted and accepted the recommendation without any modification. And we will pay the benefit provided under 6 CPC phase by phase. There is a judgment on this point in another case pertaining to 2006 CPC. Paragraph 15. The humble deponent admits the statement, they admitted that there was no any modification, admitted. The statement made in para 16 of the writ petition. However, the humble deponent submits that the state government has got overall discretion to alter or amend or modify or substitute or refuse to accept the recommendation made by the CPC from time to time as admitted by the petitioner in the corresponding paragraph 16. Emphasis supplied. The respondent state never modify or alter or amend the said recommendation of CPC to any considerable extent does not mean that government has waived their right. Yes, I do admit government has the power to waive. Where is the cabinet decision, my lord? You cannot take a decision. It has to be by way of cabinet decision. That we wanted to modify, we wanted to, my lord, so to say, alter. Therefore, arrear salary, once it is, my lord, accepted with retrospective effect, and salary will include arrear salary. The term salary always includes arrear salary. If something is not paid, it will come under arrear salary and it will be deemed to be part of the salary. Because it is your own decision. It is not our decision. You intended to, my lord, provide the retrospective effect, to give the retrospective effect. Now you are coming and say 2013 notification, Annexure B notification, imping notification 15/2/2013 is a policy decision. Whether by a stroke of imagination, can anyone say this imping notification is a, my lord, policy decision? That apart, you say by referring to 2009 notification, everything was paid. Court has also come to the conclusion everything was paid. If everything was paid, what is the occasion for you to say in 2013 that you are not 2009? These are the two contradictory, inconsistent, my lord.
Yes. Stopped. No link.
Must be problem from their side, it seems to be.
By 89 adaptation of laws and order, they
We couldn't hear you for some time. You were submitting something, but we are not. We couldn't hear you.
or not audible, madam.
It got deleted.
Oh, my lord. Then, my lord, of course, it is difficult, my lord.
You can repeat the last 2 lines you were submitting.
Yes. My lord, I am referring section 46 of the state of Arunachal Pradesh.
That we could hear that section 46. We could hear page 315. You have read. Para 15. We have heard that much.
Therefore, there was no any alteration, modification, etc. Now they are saying by referring 2009 notification that everything was paid to us. And court has also adopted a conclusion in para 36 that everything was paid to us. On what basis? By referring to 2009 notification. I have already referred to 2009, trying to, my lord inspire the court that 2009 doesn't say anything regarding payment of arrears salary. This is a notification which reflects the pre-revised pay scale and revised pay scale. And 2000, my lord, Annexure B, I have said, by referring 2006, my lord, annexure B of their affidavit, of their documents, that there was a provision for payment of area salary. They said by installment you have to pay the area salary. Therefore, there is no any provision for payment of area salary. This is not the correct position, my lord. Area salary is all along. All
It's
along
okay.
there, my lord.
That is that about 2009 that it is not reliable.
Yes.
It's repeated,
Yes.
repetitive.
Yes. Therefore, my lord, they say
Uh,
the recommendation
anything
is not
else?
binding on them.
More than that,
Recommendation
else?
is not binding.
more than that, or any?
Yes, my lord, I have something more to say. My lord, now Lordship kindly see
Yes.
the adaptation. 1987 adaptation. Adaptation is supposed to be introduced by them by exercising power under subsection 2 of section 46. Once it is adopted by the government, then it is binding on them. Now, 2000, my lord, 6 CPC is transformed into ROP Rule 2008.
That you have said already. Once
No,
adopted,
I'm
then
not
it's
saying.
binding.
No, I'm referring, my lord, adaptation, my lord. Yes. Doctor, kindly come to page 12. Page 12 of the adaptation. The copy is with you, Lord, with my lord. You should, yeah. Hello. Have you lordship got?
Yes, she's giving it to us.
You should please give.
Yes.
I've given, sir.
At page 12, my lord. In page 12. How do they say, my lord, it is not binding on them? May I read, my lord?
Yes.
Page 12.
Yes.
May I read, my lord?
Yes.
Now, therefore, in exercise of power, aforesaid, the government of state of Arunachal Pradesh hereby makes the following order. Straightway come to my lord, item number 13. In the bottom, my lord, item 13. Have you also got, my lord?
Yes.
Central Civil Service Division of Pay Rules, 1986. This is in regard to 6 CPC. The 5th CPC. Shall, unless context otherwise requires, have effect and deemed to have had effect, as if reference therein to the government or central government, government of India, government department, authorities mentioned first column, so and so, so and so, and so. Therefore, my lord, they adopted the ROP rules. Therefore, it is binding on them unless it is otherwise modified or altered by cabinet. What is the cabinet decision? To justify that there was some amendment, they took a policy decision and accordingly they issued notification on 15/2/2013. Once you are saying everything is paid, subsequently you again came with a notification saying that nothing will be paid. Is it not inconsistent statement?
Yes.
Can it be the back?
That was supposed to.
Yes. They can't have it. And my lord, at the same time, we have submitted written argument.
Yes.
Look into the written argument. Therefore, today, my lord, lordship, whether had the matter on merit or only on preliminary question?
We have already hearing on merit.
Already on merit. Then, my lord, we have also, my lord, submitted certain decisions.
Already submitted on merit. He has submitted on maintainability and you are submitting on merit.
Now, he has also submitted on merit. He has referred to certain document. Then, my lord said, we have no right. Then he referred to findings of the court. Oh, these are all pertaining to merit. And my lord, we have also referred to certain decision. Although the decision may kindly be looked into. We have given a note.
You have submitted a written argument.
Yes.
Okay.
Compilation we have submitted. Written argument and decision. And if he, my lord, makes any, my lord, anything, my lord, if he submits anything, then I may be allowed to give some, my lord.
Written
Other
argument,
than-
oh yes, we have received a written argument.
Yes, ma'am.
I'll
And
just,
there are compilation of judgment, my lord. Judgment.
Yes, we'll go through it.
Yes.
I'll just give a 2 minutes response, my lord.
Yes, yes.
My lord, my learned friend was extensively referring to the two earlier affidavits where he claims that there was an admission. Your lordship will kindly come to the affidavit that was ultimately filed, which the learned single judge relied on. That your lordship will find at page 423. What actually had happened is reflected in this
Page
affidavit.
423.
Yes.
Earlier, I think somebody has heard this argument. There are notes, but handwritings cannot be followed. Whose handwriting I do not know. There are notes, very useful notes, but cannot follow the handwriting.
Handwriting reminds me, my lord, of slightly of the case.
Hmm.
Your lordship will recall Honorable Mr. Justice B.P. Kotoki.
Yes, yes.
So he used to make notes. I have had the privilege of working with him even when he was an advocate.
Hmm.
So he used to make notes, and after a month or two, he would ask me, I can't read what I have written. Can you understand what I have?
I'm sure it must be his handwriting. I'm sure somebody has scribbled down something but illegible.
Your lordship will kindly turn to page 423.
Page 422.
That is the last affidavit when the government ultimately detected all this mischief going on. So there the position is clearly reflected what had happened.
This is your affidavit, no?
This is our affidavit filed in the writ petition.
First affidavit or second
No,
affidavit?
the last affidavit
Oh, in the writ petition.
in the writ petition,
So it will be in the appeal.
in the writ appeal, page 423.
Mm. 423.
Yes, yes, yes. I've got it. Hmm.
And if your lordship will kindly turn to page 426, paragraph 3, the exact position is narrated, my lord. Have my lord's got it. Page 426, paragraph 3. That before furnishing Paraguay's reply in response to the averment made in the writ petition, at the very outset, your answering deponent begs to state that the additional affidavit dated so-and-so filed by Sri Otem Tang is without knowledge and approval of the competent authority. Thus, the aforesaid affidavit filed by Sri so-and-so, Director Elementary Education, thereby admitting the claim of the petitioners for granting of area with effect from so-and-so and so-and-so, is without any authority, and as such, the same is discarded by the Department of Education, Government of Arunachal Pradesh. That in the instant case, next paragraph, in hand, the present incumbent of Director so-and-so had filed affidavit dated so-and-so, 18/8 so-and-so, and additional affidavit dated so-and-so, by misrepresenting the factual aspect of the case without knowledge and approval of the competent authority of the Education Department of the government level, which is serious misconduct and unbecoming of government servant, for which disciplinary action is being contemplated against him. Therefore, aforesaid affidavit filed by respondent number 6 cannot be treated as an official affidavit and stand of the Education Department for the purpose of adjudication of the present writ petition. Hence, the aforesaid affidavit filed by the respondent number 6 may not be treated as an affidavit of the Department of Education, and accordingly, the same may be discarded. The Commissioner of Education, who is the head of the department, had come to the notice of the aforesaid misconduct and illegality committed by the respondent number 6 at later stage, after receipt of letter dated so-and-so, addressed to Director Elementary Education from 1 T. Jamo so-and-so. I am not reading this one. Does not appear to, I should not read it aloud. Now, this is so far as the factual position is concerned. Now, if your lordship will kindly come to the impugned notification for a moment, which your lordship will find at page, if your lordship takes up our affidavit, filed in the writ appeal. Your Lordship will find at page 650.
Yes, page 650.
650.
Mm.
In table 1, we are concerned with table 1. Your Lordship will find under 5th CPC,
Mm,
there are 2 columns.
mm,
One is existing, the other one is revised. If your Lordship compares this existing, they are not for a moment disputing. My learned friend made an elaborate argument for almost 1 hour. He did not dispute that this was the existing scale they were getting. And this existing scale is the 5th CPC scale that I pointed out. If your Lordship will kindly come to page 631 in that same affidavit. If your Lordship sees, so therefore till 2013, no writ petition was ever filed. From 1997 to 2013, they were getting this existing scale. And if this existing scale, if your Lordship compares with 631, this is the central 5th CPC recommendation. This is what they continued to get. And that is why when my learned friend says that we have adopted the 5th CPC, he is factually correct. Because we have not only adopted, we have given them. On the right hand side, if your Lordship sees the revised scale, that is the scale meant for the Union Territories. And this additional scale, we are saying that we are fixing it notionally from 1998, and we will, actual benefit, we will give it to you from 2013. So, not even for a moment, my learned friend disputed this position that this existing scale, otherwise they would have challenged it way back in 97 itself, had they not got it. They waited till 2014 and that writ petition was also withdrawn. Subsequent writ petition, this writ petition was filed again in 2018. So essentially till 2018, they did not have any grievance at all. They became wiser. Later on, they realized that if we can get it actual benefit from 2013, why not try to get it from 1998? By completely forgetting that this is actually meant for Union Territories, not for Arunachal Pradesh. Now, a lot of emphasis has been laid on some high power committee, etc., etc. Your Lordship will kindly keep this document, page, just a moment, page 649 of our affidavit. If your Lordship keeps that page open, and they are talking a lot about this high power committee, your Lordship will kindly come to the writ appeal.
Annexure I think.
No, my lord. Annexure 4.
No. There is annexure I, that hyper committee.
High power committee, my lord, in the writ appeal, it is at page 221.
Mm.
Page 221. This is the covering letter.
No, it's fine.
I'll just take 1 minute more. Page 649 of the affidavit, your Lordship will kindly keep that document open and I will point out the high power committee one. Page 221 it starts, that is the forwarding letter of the report. If your Lordship will kindly turn to page 222.
Yes, you have shown earlier, page 222.
Yeah, I just wanted to read out one thing. Right at the bottom of page 2,
Yes.
subparagraph A, non-enforcement of Government of India's OM number so-and-so dated 4/4/2002. So the foundation of the high power committee's report is this 446 page 649, which is meant for Union Territories. So this benefit that 5 lakhs so-and-so This was calculated on the basis of this 4/4/2002, which they are not entitled to. They don't have a legal right, any enforceable legal right for this. So therefore, it appears that, my lord, in a lighter vein, my lord, for a football match, my learned friend came prepared for a badminton game. My lord. He did not answer any of the relevant, he could not point out why these documents are irrelevant and why these documents do not form part of the writ appeal. But we have also prepared a very short written argument for your lordship's convenience.
Okay.
That will make it convenient for your lordships to hear narrative
My lord,
facts and.
My lord, in reply to his, my lord, submission, short submission, I would like to say that, my lord, they said by referring to, my lord, Annexure G at page 650 of their affidavit in opposition, they said, my lord, there was a lapse on our part in not challenging that order. You issued notification in 2013. We approved the court in 2014. That matter was, my lord, remanded back to government for examination. Then they, my lord, arrived at a conclusion that we are not entitled because of financial constraints by passing an order on 4/10/2014. Then we filed
Which page?
650.
Huh?
650
Page?
of their affidavit in opposition.
Okay.
Of their affidavit in opposition, 650.
Yes.
They say
650?
that, my lord. Oh, yes. They say that there is a total inaction on our part, my lord, since, my lord, 1990 to 2013. They issued notification on 2013. Our cause of action arose in 2013. We approved the court in 2014. First writ petition 21 of 2014. That was, my lord, remanded back to government by order dated 5/5/2014. Then government, my lord, arrived at a conclusion that we are not entitled because of financial constraints by order dated 4/10/2018, 2014. Then we filed one more writ petition, my lord. And subsequently, it could have been detected that impugn order was not, my lord, enclosed in the writ petition. And therefore, the liberty was granted to us to do the writ petition and file the subsequent, my lord, writ petition. Hence, my lord, writ petition 151 of 2018. So what is the question, my lord? There is a latches on our part in not approaching the court or disputing the, my lord, decision of the government. You said everything is paid. Now you are saying nothing will be paid.
Yes,
Then-
it's okay. Yes. Yes,
On the other hand, my lord, yes, my lord, on the other hand, they said, my lord, calculation was made on the basis of, my lord, central government notification. This is not the correct position, my lord. Calculation was made, my lord, by taking into consideration the difference between revised pay scale and, my lord, pre-revised pay scale. Central government notification we never relied on. Government has referred to, my lord, that particular notification. In our petition, there is no any whisper even, my lord, that our claim is based entirely on 4/4, my lord, 2004. Central government really approved only to, my lord, Indian territory. This is not our case. Our case, as simple as is, that, my lord, the difference we are entitled because you implemented, my lord, pay commission recommendation by taking a cabinet decision, my lord, with effect from particular date. And you took a decision that you are not entitled. Benefit will be given with effect from 2013. So in that eventuality, what is the question on your part to say everything was paid to us? Now by justifying, might not to justify this, but contention therefore various documents. And we say that these documents are not at all relevant to us because we never relied on these documents.
Okay.
Kindly have a note, my lord. And
I got your point.
yes, my lord, I believe that lordship will consider our written argument as well as the decision I have already brought on record, as well as the submission. I'm obliged to your lordship.
If my learned friend is disowning 4/4/2002, he has to return all that excess money back. From 2013, whatever he has got, he will have to return back to us. Arunachal Pradesh will become a little richer.
And on the other hand, they are saying, my lord, financial constraint. I am in a position to show, my lord, the audit report. Every year, central government, my lord, allotted huge thousands of crores, my lord. Even then, they are shortage of money, my lord, to pay the salary of the teacher. who are the backbone of the society, who are the architect of the society. They are dedicating their service to build up the career of the students who are the future of Arunachal Pradesh. And they are being deprived, my lord. Very unfortunate. You should rather, in foreign country, my lord, I have gone through some journal, my lord, the highest regard is given to teachers community. Highest regard, highest pay, my lord. In my lord, UK, Netherlands, even Denmark, in our country, teachers are being deprived, always deprived, my lord. They are not being paid even their salary. Let them produce the record, show that the high brokers, they didn't get any, my lord, area salary. I will do my writ petition. Can they show? The top level officer, they didn't get any area salary. And what is your justification to say, that why did you pay area benefit to other department? Annexure 1A and 1B. They did not dispute this fact.
We will compare the discrimination. We will compare.
My
All
lord.
right.
God bless you.
Yes, this argument, this the,
Yeah. Yes,
which paragraph? I'll go through that entire
Yes.
argument. Yes.
I have kept it very brief, ma'am, so that it is convenient for you, Lord.
Okay.
I am obliged, your lordship.
Council Minister Edu Cluster for the applicant, implement. AG, Arunachal Pradesh, for the state of Arunachal Pradesh, Mr. I. Chaudhary. Assistant Council. Department Minister. Agum. It's reserved for judgment and order.
Deeply obliged.
Loose paper बहुत अच्छा can't hear you.
But am I audible?
Yep.
But there are a series of cases from serial number 19 to 24. 19 to 24, and I am in 19, 21, and 22. But in item number 19, there is an IA. In the IA, actually, I have sought instructions from my client, and my clients inform me that they are trying to contact the applicants. So they are yet to have a discussion because they have to know these applicants are seeking implementing themselves. So I may be given some time.
No objection, I also can allow. If the other side has no objection.
My lord, I am appearing for the applicant, ma'am, in item 19.
So, we'll allow.
No,
My
madam.
lord, all
We
these
are
matters
we are
may be
seeking
taken up
some
on
discussion among the my client and the applicants. So
Settlement.
for settlement, we
Settlement.
will inform your lordship. So no
We'll allow.
order may be passed today, my lord. We just give us some time.
Yes, my lord. Let it be fixed on next Monday, 22nd. 22nd.
22nd.
22nd.
Monday is not a DB day.
No, not a DVD.
So we'll fix it on Tuesday then.
No, this is a single bench matter.
Okay.
Well, well, may I pray that my little recommendation, my lord, on 30, my lord.
30.
My lord.
My lord, I am appearing for respondent number 7 and 8, my lord. I have filed in item number 20, my lord. It is very.
Take up one by one then.
No, my lord, let it be fixed on 22nd. My lord, there is an interim. Yes.
22nd, my lord.
22nd. Monday.
You are asking for 30.
My lord, I am asking for 30 or 29, my lord, Monday.
30 can be okay, my lord.
Next Monday.
30
Next
or 29.
Monday.
29 is, my lord. 29, my lord.
Is okay.
My lord.
Because in this
29 is Monday, my lord.
Item number 20.
29 is Monday, my lord.
Last sir is appearing, so he will not be available Monday. So
On 29.
30.
Is a division bench.
Item number 20.
Item 19,
19
20,
to 24, my lord.
19 to 24.
20, 21. 92, 23, 24. Okay, as agreed by both the parties, list this matter on
29,
29,
my lord. June.
29.
Yes, my lord.
My lord, I have one small prayer in WPC number 171 in the serial number 19. There is an interim order that may be continued, my lord.
Interim order in IA or in WPC 171. Yes. Interim order in WPC 171 stroke 2026 will remain in force till then.
Yes, my lord.
IA is in one regulation 576, my lord. Then that also interim order is there.
IA?
No,
Interim order in 576 also may
576, my lord.
continue.
IA?
No, interim order is in
WPC 576.
576.
Item number 20, madam.
76.
Item number 20.
117 2026 and 576 2025.
Yes.
Apply.
Obliged, Lordship.
From there, please.
My lord, from item number 3 to 6, my lord, this matter basically offset of the dispute between husband and wife. My lord. So since after a long time this matter has been listed, my lord. So I have to get some further instruction about what the subsequent development.
Yes.
between them.
I am for the respondent.
Any objection?
So where, my
Yeah,
lord,
we allow.
after summer vacation, my lord, this matter may be.
After summer vacation? Okay.
3 to 6, my lord.
3 to
6.
6.
Connect.
3, 4, 5, and 6.
Yes.
Okay. Learned Counsel, Mr. R. Sonar,
My lord.
with the consent of the other side, has prayed for adjournment. What was the ground?
Ground, my lord, I need some further instruction from the court.
As further instructions are to be sought from the petitioners. Okay. Petitioners. List this matter
After summer.
vacation. List this matter after summer vacation.
Much.
DP of luck.
Lordship, here is some unlist matter for listing on 17, for the listing on 17. This
List
there is a
when?
17, Wednesday.
To mention item number 26, my lord.
26.
On behalf of Charpak Modi, counsel for the petitioner, ma'am. And list this matter after 3 weeks, madam.
You're asking for adjournment?
Yes, ma'am.
Any
I have
objection?
4. No.
No
Private respondent number 4.
Learned Counsel, Mr.
And UB, ma'am.
and
UB.
UB on behalf of Learned Counsel, Mr. C. Modi, with the consent of the other side, has prayed for adjournment. Learned Counsel, Mr.
S. Die.
S. Tai. Government
No. For private respondent.
is present for the private respondent number 4 and Learned Counsel, Learned Government Advocate, no?
Yes.
Mr. Y. Ridam
Yes.
is present for how many respondents?
1, 2, and 3.
1, 2, and 3. List this matter when you want?
After 3 weeks, ma'am.
3 weeks.
Yes, ma'am.
List this matter after 3 weeks.
Obliged.
Item number 1.
Your Lordship, the instant petitioner here have filed on different occasions WPC 39923, WPC 40123, WPC 39823, WPC 423, challenging the termination order of the petitioners, wherein the petitioners were appointed as regular primary teachers. The termination order dated 26/2023 was challenged in these petitions, in these WPCs issued by the Commissioner Education.
You have to issue notice.
Yes, notice only at this stage.
They have not complied with the order of this court.
No, it has
You have
passed
to
4
issue
months.
notice, okay. The petition, Learned Counsel, Mr.
Joel Koyo.
Huh?
Joel Koyo, J Koyo.
J. Koi. BJ Kohu, no?
Yes, sir.
Is present and has submitted that the petitioners are aggrieved by the aggrieved as the respondent has not complied with the order of this court, huh?
Yes, Your Lordship.
Order of this court dated
Dated 2011-2025.
in connection with a series of my order.
Yes, Your Lordship.
Okay. In connection with a series of writ petitions. Issue notice to the respondent returnable within 4 weeks. List accordingly.
Item number 2.
May I please, Your Lordship? Your Lordship, kindly, the matter may be kindly fixed at 2, Your Lordship. My arguing senior counsel is on legs on another court, so he will connect to VC.
Okay, he'll connect to VC.
Yes.
Okay, there's a request for fixing this matter at 2. We'll take up at 2. All right.
Oblige, Your Lordship.
Item number 7.
VC. Not appearing. Petitioner is not represented. Oh. Petitioner, but you are representing, no? Petitioner is not represented. Learned Counsel Miss
Waigao Lordship, on
Why?
behalf of M. Waigao.
Waigao on behalf of
M. Kato Lordship.
Learned DSGI.
Yes, Lordship.
Mr. M. Kato is present for the respondent. Please this matter after 3 weeks.
Okay, Lordship.
Because after 3 weeks, the summer vacations will be over, no?
Yes, Lordship. Okay, Lordship.
Item number 8.
May I please, my lord? My lord, in this case, the contention of the petitioner is that, my lord, dehorsed the jurisdiction, my lord, the Deputy Commissioner Tawang has issued a show cause notice and debarred the petitioner from participating in a retender process. If my lord may kindly peruse the order dated 15/9/2025.
You'll be arguing.
My lord.
My lord, I'll insist, my lord, for disposal of the matter because it's a tender matter, my lord, is pending for so long, my lord. Urgency is there.
Disposal.
It's a very simple issue, my lord.
My lord, I'll not object to what my friends, my lord, but
Okay. That is good enough then.
my lord,
Because tender matter
correct, my lord.
relating to roads,
No, it's construction of,
building, my lord.
building.
yes, my lord, girls hostel, my lord, this is.
Also, in which
If my lord may kindly peruse Tawang, my lord. Yes.
college?
School.
School, my lord.
Okay.
If my lord may kindly peruse the order of this honorable court dated 15/9/2025. By that order, I was allowed to participate in the retender process, and there was a further stipulation that the result of that tender shall not be declared. Order dated 15/9/2025.
$15.9, no?
2025. Order of this honorable court, my lord.
Which way?
Order of this honorable court, my lord.
Court's order.
My lord.
I'm checking the annexures. 15/9/2025.
My issue is very simple, my lord. The Deputy Commissioner has no jurisdiction, and by exceeding the jurisdiction, he has issued a show cause notice and debarred me from participating in a retender process. By order of this honorable court at the stage of motion, my lord, I was allowed to participate in the tender process, but there was a further caveat that stating that the result shall not be declared without the leave of this honorable court. So therefore, my lord, this matter can be disposed of with the direction to declare the result, my lord. That's all.
Okay, we'll.
My lord may do that, my lord. Only my submission is that, my lord, the deputy commissioner, my lord, as a head of the district administration, when some law and order problem comes, my lord, it is his duty to look into it, to that matter, my lord. My lord may allow this petition, my lord, with some observation that petitioner will not resort to any law and order problem, my lord. That is the main crux, my lord. Why the deputy commissioner is there? Because he may handle the officers, my lord. The tendering
No, my lord,
officer.
to that effect, there's a FIR, and that FIR is already being stated by this honorable court. That is not the
That is
issue here.
different issue, my
That's not
lord.
the
But
issue here.
he should not, my lord, manhandle or intimate the tender authorities. That's all, my lord.
My lord will find impugn order at page number 33, my lord.
Or here, my lord, that is the only,
Go through all this, I'll just copy this order
my lord.
and then I'll just pass an order.
And the person order, my lord, saying that, my lord, whatever decision, my lord, the petitioner, they should accept it, my lord.
Dictate the order now.
My lord.
You can hear me out. You are agreeing with the order dated 18/8/2025, no?
My lord. Page number 33.
Same parties were present in the first day, 15/9/2025.
My lord, my lord.
So that order dated 15/9/2025. Order dated. I'll just say which paragraphs you have to copy here. You see, paragraph 1. Paragraphs are not numbered. You count and then you didn't note it down. Or paragraph 1 of the order dated 15/9/2025.
I have the copy of the order.
No, she can copy it. Paragraph 2. You'll count. You'll count. Oh, you can help me with a copy.
My lord.
You give it to me. Give it to me. I'll write the paragraphs. Paragraph 3. I'm cutting off one line, huh? With the pencil. Don't cut. Don't type that line. I have written what new paragraph? Paragraph 4, huh? I have considered, then you from paragraph 5 you write. The other paragraphs are not required. So I have paragraph 5. I have considered the submissions at the bar. Full stop. It is submitted that the petitioner has already participated in the retendering process.
My lord.
And the results are yet to be declared. Full stop. As the as by order dated 15/9/2025 of this court, it was directed that the result shall not be declared without the leave of this court. The respondents are unable. One respondent, no?
No, my lord, 1 to 5, 5 respondents, my lord.
But it will be one only, respondent one, no?
This will be executive engineer.
Who is to declare the result?
Who will declare?
My lord, executive engineer, WRD Tawang. Respondent number 5.
The respondent number 5, executive engineer, Water Resource Department, Tawang Tawang division is unable to declare the results. Thereby, considering the entire aspect of the matter, the respondent number 5 is allowed to declare the result, the results of the
Tender process, my lord.
result of the tender process. Full stop. It is also submitted that I have also considered the submission that that a condition may be imposed that the petitioner may not
May not create any law and order problem, my lord. That was the main reason by the deputy commissioner.
may not create any law and order problem during the declaration of results.
My lord.
Full stop. Considering the submission, it is directed that the result may be declared by the respondent number 5 under the condition that the petitioner may not create any law and order condition.
It's not,
Law and
not
problem.
necessary at all, my lord, this observation, but still in my lord may kind.
My lord, that is the reason, my lord, why deputy commissioner passed, because peace and tranquility of district is the prime concern of the deputy commissioner.
That order itself is wrong, my lord, without jurisdiction.
No.
My lord, may kindly peruse page number 33.
The district magistrate, my lord, yes, the authority. my
No,
lord.
but why was it debarred from participating in only because he was aggressive?
My lord.
That's the reason, my
Only
lord.
because he was
Yes,
Not
no
only
jurisdiction,
aggressive, my
no
lord. Not
authority
only
at all.
aggressive, he manhandled, he intimidated the officer, my lord. That is the reason, my lord.
And my lord, may
Obliged.
kindly peruse page number 33. That has to be set aside, my lord. The order of the deputy
Deputy
commissioner.
commissioner, yes.
Oh, yes, of course. The order dated, it has to be set aside.
18 August 2025, my lord.
Which page? 33.
33, my lord.
So it is necessary then.
My lord,
I think so.
Yeah.
That condition has to be imposed.
Imposed, my lord, yes.
The order dated 18/3, the order number TPA-03/2025-26 dated 18/8/2025 is hereby
Passed by the deputy commissioner Tawang, my lord.
passed by the
Deputy Commissioner Tawang.
Commissioner Tawang is hereby set aside.
Grateful, my lord.
My lord, next order, similar, my lord.
Same.
Same.
Item number 9. So this Muni, this I have put inside this. You copy all this from this.
Same order, my lord. Only the petitioner is different.
Same order?
Same order, same order, same
Okay. These are two different forms.
two different forms, two participants.
Why they were so aggressive? Two forms on the same day?
That is the allegation, and to that effect, there's an FIR which is pending before the police station Tawang, and that FIR has been stayed by this honorable court. That is altogether a different subject matter, man.
All right, my lord. That is not a certificate of election. It is different, my lord. Anyway, my lord, same order will pass in item number 9.
And it was passed on the same day?
Same day, my lord, same order, same impugned order.
You change the name of the petitioners.
That's right.
And even this notification, same page, 32.
My lord,
No. Okay, this is page 31.
31. 31. Grateful, man.
Item number 10.
Copy is in the first item, huh? First item will be, this was 8, no? The copy is in the item number 8.
Mayor. But to this petition, item number 10. The petitioner, who is presently working as an assistant engineer, posted at Tipu subdivision, he is assailing the legality and validity of the impugned transfer order dated 15/9/2025, which is annexure number 1. It's a case of frequent transfer. Within a period of 1 year, he has been subjected to 4 times transfer. So the latest transfer, even like RTI was sought for, saying that what is the reason? Basically, knows like transfer incident of service. Definitely transfer can be done, but there should be some administrative.
Within how many years he was
Within a
transferred
1 year.
times?
Within a 1 year,
Okay.
within a 1 year. So I will come with this documents showing how transfer was affected. May I take to page number 19, is the impugned transfer order dated, 19, Yes, madam. My name is at serial number 3, madam. Hano Mangfi, a Tipu subdivision to Pijiring subdivision against existing vacancy. This impugned transfer has been stayed by this honorable court, madam. But this order, it was issued on 15/9/2025. This is the impugned order, the latest order. Then, my lord, may I take to page number 20 onwards, so where I can show my lord earlier transfer order, my lord.
Okay.
It starts from page number 20 onwards, my lord. My lord will find, my lord, here on 15th October 2024, my lord. 15th October, my name is at serial number 2, my lord. At that point of time, I was working as A Bumming subdivision. Thereafter, I was transferred as A Balijan subdivision, my lord. Is number 20. This is the 15 October 2024.
Yes, yes.
Thereafter, my lord, may kindly turn to the type copy, my lord, page number 22, my lord. Then with November, my lord, then within January, 15 January, within 3 months again, my lord, my name is serial number 3. Then that transfer, my lord, although that transfer was done, but that was modified, my lord. Then and modified, and I was posted as ASW SEPA division. My lord has seen the date, my lord, 15 January 2020. Thereafter, again, my lord, kindly turn to page number 23.
Page 23 is.
17 May 2025. Last posting, my lord.
Yes, yes.
Then, my lord, ASW SEPA, I was transferred to the present posting place. So then, my lord, 17 May, then my lord will see within, my lord, May, June, July, within
1 year.
my lord, within 4 months. This is a May 2025. The impugned order, it was passed on September 15, 2020. Within 4 months. Altogether, my lord, I have just shown, my lord, that on the records, my lord, within 1 year, I was subjected to 4-time transfer, my lord. At this time transfer, my lord, immediately I submitted the representation. I first approached the concerned authority. They realized that it will be looked into consideration. Filed the representation, which is still pending, my lord. Then, my lord, I filed, my lord, RTI. Very interesting, my lord, their response, RTI, they will show, my lord, and it is in the affidavit also, they have not disputed about whatever that is given in the RTI also. Kindly turn to page number 25, my lord, annexure 4. I wanted to have the file notings, proposal, reasons why I have been again within so short time, my lord, transferred, my lord. Then their response, my lord. My lord, kindly from below, my lord, 2, second number, my lord. copy of file noting and related correspondence. I sought for file notings, how transfer was proposed. Then say that no such noting or correspondence is available on record in the established. Even no approval from the competent authority. And this fact has not been disputed in the affidavit also. Now, 3 reasons. Reason justification recorded for effecting the transfer with less than 1 year. The reason in the matter are not available due to non-availability of the relevant records. And they have not brought on the affidavit also, my lord, records. What are the reasons, my lord? Copy of the recommendation approval of the competent authority. The recommendation approval along with it is not available in the consent file. So, my lord, only the thing what they have served me, the authority, is only the transfer order without disclosing any reason, my lord.
No noting.
Nothing, nothing, my lord.
No order.
No approval, nothing.
Approval, no.
My lord, period of 4 months again. Now, my lord, this policy guidelines is there, which basically prescribe a officer should be posted generally, my lord, is for 2 years. Of course, my lord, I admit, my lord, this does not provide me a enforceable right to insist that I will be there for the 2 years whole, my lord. No, that is not the law. But the law says, my lord, that when there is that standard is being professed by the employee, my lord, employer, it is a legitimate expectation of the employee that definitely the employer will go by the professed standard. And the law says that while effecting transfer within the 2 years, if the authority doesn't give consideration to this particular relevant factor, that it amounts to arbitrary, my lord. It's not absolutely bar, my lord. Transfer can be done, my lord. But the issue is that, my lord, whether you have taken all the relevant factors into consideration, including the 2 years guideline, my lord. This has to be also there, my lord. But here in the case, my lord, on the record, nothing is there, my lord. I don't know, like only the order that is only there, my lord. Even on affidavit also, they have not brought nothing, my lord. Now, what I am submitting, my lord, is that none considering the policy guidelines, what is the justification, that reasonable justification that they are, which warranted deviation from this particular professed guidelines? This is not there in this case, first. Then, my lord, this is a case of, if I will not say malice in fact, my lord, so apparent this is a malice in law, my lord. But when there is no reason, no recorded reason, no cogent reason, my lord, nothing is there, my lord, and this amounts to, my lord, malice in law. There is no approval, no office noting, no discernible any administrative and basis, my lord, public interest, my lord. Only a sweeping statement that in the interest of administrative exigency. That will not suffice, my lord. Material has to be there, how, my lord?
Yes.
That conclusion, my lord, that is not there in this case. Nothing is there, my lord. Now, my lord, frequent transfer. This is not the case. Otherwise, also had not been even frequent, my lord. Otherwise, even not sustainable in law, the manner in which the transfer has been effected. But my case stands in a more strong footing, my lord, within 1 year, my lord, 4 times. My lord. This is a systematic putting harassment on me, my lord. I have my family, my lord.
So how far are its places?
From, my lord, right now, transfer is from PGRM, Pipu to PGRM. My lord, Pipu, it's bit of, my lord, remote area. Road condition is also not that good, but it is within the district, same district. But one day, my lord, road condition, all these things are very bad, my lord. Of course, within the same district, my lord. That is there. Now,
Your family?
my family are at Seppa, my lord. Well, since I have to make frequent come and go, and there is a remote area.
Seppa is a remote area.
Seppa is a district headquarters.
Okay.
The Pipu is a remote area, my lord.
Pipu is a remote area.
Remote area. Hardly, I think, somehow, now it must be cut off because of this rainy season.
Okay.
Otherwise, even this vehicle, I think, only last 2 years before only, I think, this PMG Swai road that was made, my lord.
Okay.
So this was a remote part of this. Now, my lord, transfer, my lord, if it is for public interest, administrative agency, of course, I cannot deny. I have to go, but not in this manner, which is basically my submission. But there has to be something. Now, my lord, this is the order in which way this exercise, my lord, it defies the necessary principle of reasonableness and principle of proportionality, my lord. There was no reasonable person, my lord.
Okay.
Any person who is reasonably acting, my lord, would resort to this kind of frequent transfer. Any reasonable employment.
Yes.
And that's why, my lord, this is not only violation of the 14th article, my lord, even Article 21, my lord, because I have a right to live in a, my lord, dignified and in a, my lord, way, my lord. If I made to subject like a debt, within 3 months, 4 months, you have to go there. That also amounts to Article 41, my lord, which is the fundamental rights, apart from 14, my lord, arbitrariness. That is also there, my lord. Therefore, in view of above, my lord, this transfer order, my lord, is not legally sustainable, my lord. These are the basic, my lord. In transfer matter, there is nothing now. In affidavit, nothing. No records, nothing. Only say that administrative, that is only there. My lord, they will say. I'll just, my lord, place 3 judgments only. Just to show, my lord, one judgment, our own High Court only, my lord. Excuse me. My lord, this division bench judgment 2024-1 GLT-1, my lord. My lord, in this judgment, my lord, para 10, 11, 12, 20, this judgment has dealt with, my lord, para, my lord, do I require to read all the things or I'll just refer the paragraphs, my lord?
Only paragraph?
Paragraphs, my lord. Para 10, 11, 12, 21, 22, 25, 27, my lord.
10, 11,
12,
10, 11,
12,
12,
21, 22, 25, and 27. So in nutshell, I will just, this
Yeah,
judgment, my lord.
you can read the judgment?
Yes, my lord.
Or small paragraphs?
Yes, my lord. I'll just read this judgment. Para 10 is saying, my lord, it's dealing with the, my lord, all those earlier judgment dealing with the apex court judgment in so that how transfer can be done. Then, my lord, it said, well, para 11, I will read, my lord. Para 11. The Honorable Apex Court, while dealing with the decision of transfer order issued by the full court so and so, reported in so and so, also extensively deal with the concept of malified exercise of power relating to order of transfer. At paragraph 58, the Honorable Apex Court held that the state is under the obligation to act fairly without ill will or malice in fact or law. It further went to hold that the legal malice or malice in law means something done without lawful excuse. It is an act done wrongfully and willfully without reasonable and probable cause, not necessarily an act done from ill feeling and spite. It was further held that when an order is not based on any factor germane for passing an order for transfer an order, the order is based on an irrelevant ground, such order is not be admissible in law, my lord. Regarding, my lord, this policy guidelines, para 12, my lord. The transfer policies and guidelines are formulated to regulate the policy of the government employer. Such policy generally includes the tenure of posting, the different conditions of transfer, which are formulated on the basis of the need of the department. Therefore, such policy and guidelines are judicially declared to have not created any enforceable right upon employee. The Honorable Apex Court, in the case of so and so, dealing with the transfer policy of the Madhya Pradesh High Court and recognizing the principle that the transfer policy and guidelines are not having any enforceable, relying on earlier decision of the Honorable, held that though mere reasonable or legitimate expectation of a citizen may not by itself be a distinct enforceable right, but failure to consider and to give due weightage to it may render the decision arbitrary. It was further held that requirement of due consideration of the legitimate expectation forms part of the principle of non-arbitrariness, which is a necessary concomitant of a rule of law. Finally, the Honorable Apex Court held that though the transfer policy may not be enforceable in law, but when such transfer policy has been framed, every officer will have a legitimate expectation that such policy should be given due weightage when cases of transfer of officer are being considered. Basically, why I'm relying, my lord, this is something you cannot just set aside and say that it being not enforceable, I will not give it. No, that amounts to arbitrariness. Now, what is that? You have to take into consideration that factors also that there is a policy. And in general case, you have to follow that policy. Exceptional case demands exceptional treatment. But here, my lord, what is that exceptional treatment? 4 times. So that argument will not suffice that since it is a policy guidelines, you not enforceable, you can be made to transfer every second day. That argument, my lord, not be accepted. And that will be against the rule of law, my lord. And that will form the part of arbitrariness, my lord. Discrimination, my lord. Violative Article 21, my lord. Then, my lord, this para 21, rest of hearing this case also that proposal for the transfer that was not originated from the administrative department. That's why this division of this Honorable Court says that that is wrong. It cannot be that proposal has to be come from the concerned administrative department. It's not something XYZ anybody will propose and thereby you can effect that. Then that will say that this transfer, all this is malice in law because no reasonable person would have passed in such a manner, my lord. So on that basis, my lord, I have put this particular judgment, my lord. Now, rest of the 2 judgment, my lord, 2024 Supreme 105, that is pertaining to, my lord, frequent transfer, where, my lord, said that frequent transfer has been held, my lord, illegal, my lord. My lord will, 2024 Supreme 1059, my lord, para 9, my lord. Thank you. Frequent transfer. Here also justification was given, but that justification was not accepted by the court, saying that this frequent transfer cannot be overlooked. This submission was made on behalf of the department. The office will rely upon the petitioner, not applicable in that. Even accepting for argument's sake, there is a submission that aspect of frequent transfer cannot be overlooked. So there is no manner of doubt that those people are transferable, which may be done in public interest following the process. Frequent transfer of the present nature cannot be endorsed by the court in the rest of justice. In that case, also, my lord, within less than 4 months, the transfer was effected. One more judgment I would like to rely on is 2006. Supreme Court.
This person, Susanta Devnath, he was transferred how many times?
Here in this case, my lord, five times within 4 years. So within 4 years, there was 5 times. But for me, my lord, within 1 year, 4 times. My lord.
Which paragraph?
Finally, we'll find it. There are 7, my lord. At the bottom, my lord.
Okay.
Then I would like to rely one more judgment, 2006 Supreme Court Law 195, my lord. Here, my lord, this frequent transfer was done, and this about this policy transfer. Here, my lord, within for 2 minutes, transfer was effected. There are 13 months. saying, well, these policy guidelines, it is not something you can just keep blindly you can find. And frequent transfers has to be considered. 13 months. So, executive instruction of such nature as indicated above is not having any between but the requirement described therein as the guideline needs to be taken into consideration by the government taking any decision for transfer and any purpose of the same. Such executive instructions there must be permitted to be frustrated. Admittedly, it is a case out of turn transfer because an officer is normally allowed to continue for 3 years in the place of posting. In the case that the petitioner was transferred immediately after the commission. Significantly, this transfer has not been justified by recording any cogent or plausible wrongdoing prior to placement of the same reported on the schools. It is settled that the administrative action must be reasonable, fair, and transparent. In the instant case, into transfer order lacks appendix and transparency. This is so it's. But there are a number of decision figures. So I conclude my argument by saying that. Transfer, it is not something cannot be done. But when frequent transfer is concerned, there are exceptional circumstances. It's something very exceptional that only my eyes should be there. That rare and exceptional circumstances. In such cases, there are 4 times, that definitely, here in the case, forget about this exceptional or rare. It's no reason.
He's an engineer, no?
That's
Yes, government.
Right for the SL transfer and posting repeatedly in the said incident of service matter. That cannot be divided. That will be delayed. When there is a service matter, obviously there will be transfer and post. Now, fundamental rules, rules 15.
FR, sir.
FR. Yes, sir. FR 15 says.
Where is the FR, sir?
FR, sir.
What one? FR, sir.
Under 15, my lord, governor for the competent authorities, my lord. Well, they are the authorized, my lord, to transfer the any agent and dependent. My lord, there is no any embargo that he cannot be transferred secretly. So that empowers the authority to transfer agent when in public investment. Now, here is the case, what we are saying, my lord, that he has been transferred of 4 times in a year. Right, mother? That is the first condition of petition. I'll demonstrate that it is not correct, mother. Not 4 times, perhaps at the most 3 times. Why, my lord? Transfer order dated, my lord, this one, 15 October 2024 was ever acted. So this cannot be, Malak.
15 October 2024.
Yes, Malak.
Was never acted upon.
Was not Malak acted upon. Right, Malak? Then, Malak, 15 January 2025. Now this transfer order was modified. Right, Malak? Suitable to the petitioner. And he gladly accepted. There is no any problem with this transfer order, madam. Right, madam? Because he got the choosing place of possible. Right. So that way, madam, in a year, in true sense, he has been transferred twice, madam, not 4 times. Now, madam, coming to my look. Approval, my lord. We said, my lord, there is no approval. My lord, if there is no approval, there will be transferred. Now, you also to see, my lord, who issued the transfer order? Is the competent officer or not? Obviously, that will be issued only on approval. So that way, that is also not correct conclusion. You could have said,
There has to be note. There has to be note. The note has to be placed before the authority, and the authority will.
not required, not required. Now we are in digital, in the digital.
No, then it will be arbitrary. If there is no proposal and then no approval, and then it is just order is passed, then it will be arbitrary.
See, there was a proposal, what they are saying, note. Proper, note, not from where, it from the politician or from the department,
From the department.
Department. Obviously,
From the drawing and disbursing officer.
Obviously, that was
Approval has to be.
He was not transferred as single. What 16 include what as well. If you know that, this is the 15th September 2025. This is a no transfer policy. It cannot be done in the state of Malak.
Where?
Malak, lecture one. 15th September 2025. This is the interval. Page 19, of the petition.
So you say that this was not acted upon?
No, madam, not this one. This is the interim order right now.
Or
I said
present order, okay.
Page 20, madam.
Page 20 was not acted upon. Why?
It was not acted upon, madam.
Why? Because what is the reason?
Why this was not acted upon, madam? It is not a subject matter, madam. No one dispute, madam. It is petitioner. That's not dispute, madam. It was not acted upon.
Okay, he will not dispute.
Madam, no one
If it is not acted upon, he will not dispute.
That's why I said, madam, when he got the suitable class of costume, madam, he gladly accepted. He never disputed, madam. Anyway, madam. Now coming to madam, page 19, madam. This is the interim order. 15th September. Madam, there are 4 officers, madam. Right, madam?
Yes.
Petitioner is placed in number 3, madam. People subdivision. Earlier, madam, where he was married? You lost in the candy? Sorry, I'm bothering page 22.
No problem, no problem. Page 22.
Yes, madam. You lost your finding, madam, serial number 3. Well, Sepa Devi.
Sepa.
Rightly, madam, very fairly admitted within the same.
Okay.
Divisions are different. Because he holds, madam, not the madam, head of the division, with the assistant division. So, under one division, there can be 3 more distinct divisions. So, Pirpur is one of the subdivision of this environment. So basically, he belongs to Sepa division, but he has been his place of working is Pirpur subdivision. Right, the division is same. Only working place is different. So hardly my lord, it will be around maximum say 15 to maximum 30 kilometers. That's why Mala, his family still is apart. Immediately, yes. So, Mala, there is no any personal hospital. Right, madam? There will not transfer of
no roads, he is saying. No roads.
Road, madam.
No roads, he has stated no, there are no roads.
The road is perfectly all right now, madam. It's a motorable road, madam. I'm sorry, madam. You also can ask anybody from Sepa, madam. I think my friend, madam, he aware of that, madam. Now it's a motorable road, madam. So far, landslide, natural crime is concerned, madam, no one can control. I'm sorry, madam. Especially in hilly area, Himalayan range, madam. It's for notice the reason. This is the time of the madam, time for madam, flood and that time. No one can control. But if poor madam subdivision is a motorable, that I can say. Then third mallo, he says the competent authority not approval, there is no reason. Right, madam? I can show you, madam, if you order itself, madam. You also kindly come to page 19, madam.
Page 19 is.
19, madam, this is the interim order. Right, madam?
In public service.
Public service there, madam. there is a vacancy of postman. Because he being a mellow on the senior officer, we want that senior man to win that area man. Vigilance service against existing vacancy man. So is this not a public investment? We want that senior officer to be invested.
But
Can that be a mellow, any malassing law matter? If so, if suppose any vacancy there, we want to take advantage of some experienced officer mellow. And there be a malaise matter to no matter because of my people transfer 1 to 2 times. There cannot be a matter any one of any government. In another says, he says, matter. Transfer of posting is an incident service matter. Agent Rain, yet already taken undertaking that he will resolution. Now, only things matter he has to demonstrate matter that there is a malafide. He cannot because there is no reliable matter. We are planning to release it so that we can possible. But immediately we want that the vacancy should be enough. The heat is on the senior most of the time. We want to get better problems. And that is the qualified reason and so far the reason is concerned, there are 18 of Jasmine Malor. If the transfer of posting order is in better public interest matter, there can be a better reason against that. So in other matter, there may not be any reason given. But if the purpose, if the nexus is there to achieve the better public interest, even for railway in particular. I'll be giving that matter sufficient. Now, my lord, guidelines, this guidelines is given us lots of powers, my lord. No serious must have observed, my lord. There are it will be deviation from one drug to another. So, says, my lord, since you have formulated the guideline, it is your duty to follow. Right, my lord. Right from my lord, correctly remember, this might be my SL Abbas, it says, SL Abbas, yes, 1992. Now, in SL Abbas, 3 things have been laid down. Number 1, under what circumstances, my lord, the transparent posting order can be interfered with. Number 1, malafide. Right, madam? Malafide. Then, second is, my lord, there is a violation of provision, madam. Number 3, the transferring authority is incompetent to transfer. These are the, my lord, 3 grounds laid down by the effects of SL Abbas. By saying that, my lord, there is also observation, my lord, in SL Abbas. I will not dispute, my lord. Yes, my lord, the transfer posting when there is, my lord, that must be taken into consideration when transferring. I admit that, it was categorically observing SL Abbas case. It was also, my lord, made clear typically by the Supreme Court there. So, for representation also. Yes, if there is any representation, the duty bound of the person to look into and pass it appropriate orders. Right, my lord? I am not disputing that. But can there be a ground, my lord, to disobey the transport posting of the. So, under the circumstances, my lord, now, my lord, SC section, now, my lord, 2006, when the Supreme Court says, my lord, it is the duty bound upon the government employee in the case of transport posting. First, you go there, join there, then you ventilated your grievances before the court or send the representation. Right, my lord? And here's the case between Parvas, my lord. He never joined his place of posting, my lord. Instead, he rushed to the court, ventilating. Look, I've been transferred of within near my court and take the body of this man. So that also, my lord, not as per the directive of the Supreme Court, SC section number. Now, in overall, my lord, we say, my lord, transfer and posting. Sometimes we need to see, yes,
Transfer posting, my lord, can be, my lord, it may have, my lord, malice in both fact and both. If the transfer was in the way of malice, or he has been demoted, either in any way, either the state has financially, position, whatsoever maybe. If that be sure, then it is anywhere. But there is the case, my lord. There is no demotion of my case, no state of my downgrade, my lord. No personal hardship to my lord. It is within the same division, my lord. Only the working place is different. In first stage, the submission of the petitioner is different, my lord. He said, look, there is no believer. If the lordship sees, my lord, the transfer posting order was passed on, my lord, 15 September 2025. And after 6 months, he appealed for this court. The court, the Honorable Court, inclined to call to improve order only on the ground that there is no relief. And let be a ground, my lord. Only, my lord, the petitioner, why you should, my lord, insist that the government, my lord, they should send a other post official to relieve him. What is businessman? What is his business, my lord, as a model employee, my lord? You should report to the press person, my lord. And on top of the it is same district. And he belongs to the same, my lord, the locality also. The person, my lord, the petitioner, belongs to Malasya. Same district, my lord. That is also against the, my lord.
Petitioner belongs to Pipu or SEPA?
SEPA is a district, my lord. Pipu is a sub-division. So within the same other district. Now, when you say, my lord, the transfer of posting bad, there is bar also, my lord. You can transfer there. But in district, my lord, you cannot follow there also because of all this official. So that's how, my lord, we need to adjustment. Otherwise, still if we follow, my lord, then no local officer will can transfer. Then who will make the court? If you don't make it, then how division will concern? So that's how the administration will concern. But here is the case, my lord, neither there is malice in fact, neither malice in law, my lord. But only they saying, my lord, that there will transfer or repeat. That is also not correct. No court has become more stricter. But under what ground, my lord? Is there any malafide impression? No. It is in greater public interest because there is a vacancy of the post. You being a senior officer, your service is more required. This is the only ground. And second is, my lord, you have been not transferred from the same division. So there is no question in the past. But these are the facts, my lord. On this ground, my lord, I don't think so.
You have the judgments?
Judgment, my lord, yes, my lord. I have, my lord, given SL Abbas and SC section, then Paduru. This is the latest judgment passed on the transfer posting by 2025. My lord, fusion of all my transfer posting.
So this SR Abbas, which paragraph?
Paragraph 6 and 75. 6 and 7, yes, ma'am.
Paragraph 6 and 7.
And SC section, section 9.
Yes.
This is the division bench order of the Guwahati High Court, where there is a public interest. This must be paragraph 20.
Paragraph 23.
Yes, it's not on 23. Because of this financial case, we do not send an officer to the meeting because there is status quo of it. Once the status quo is passed, it's vacated, we are going to based on
Okay.
That's what my lord, no interference for.
See, I agree with him. Why I'm saying one order was not effected, and the other order you are posted in your place of choice. So, and the third order, the fourth order, now according to me, there is only two orders. Because you have got the post, taken the place of posting of your choice in the second order. Then third order, you are agreed because the place is in a remote area. So I agree with the government. Yes.
Well, first, my lord.
I will dictate the order.
First, we have to say, my lord. The admitted position, my lord. May I check to the my lord, the affidavit?
These oral submissions, my lord, cannot replace the requirement of the contemporary records of the competent authority who exercise the mind, which requires to exercise the mind that why I should be transferred and posted. Where is that contemporary record justifying? Under what circumstances? The proposal was initiated, discussion was made that my requirement is there.
No, you see,
it is not there.
So now you'll have to, then this writ petition will be relating to the departmental procedure adopted.
No, my lord, that's why, my lord, what is the?
We cannot rake into all those matters.
No. What is the requirement, my lord? Whenever, let's forget about 3-4 times even. Suppose a person is, example, my lord, a person is transferred, recently he joined. Let's assume this is the first transfer. Now within.
I know there is a defect, no doubt about it.
Yes, ma'am. Now that's why.
A note has to be put up. Then that it has to be approved by, a note has to be put up by the assistant. It has to be approved by the authority. The reasons have to be recorded. Nothing. Nothing is there.
That's why, my lord, may I?
But that cannot be dealt with in this petition.
Well, my lord, this has to be dealt with because why, my lord? My transfer under what basis? What is the basis, my lord? That
so have you given this ground in the petition?
Yes, my lord. That's why, my lord, RTI, I filed RTI. I wanted to know why my transfer has been initiated. Now, what is the response in the RTI? My lord, I have read out the RTI. No file is there. No reason is there.
So at best I can do, if you are agitating the procedural defect.
No, procedural defect, my lord, matter is.
I can send it back to the department to correct for correctional measures to be adopted.
No, my lord, of course, my representation is pending, my lord. What's my case is, my lord, whether this particular transfer order, how they will justify it. My lord, is there any record to justify? Because this transfer has to be justified. My lord, what is there in the affidavit, government affidavit? May I take to the, my lord, kindly take to the affidavit, my lord.
Let me read your petition first.
My lord, my lord.
Where have you agitated that procedure was wrong? Then no malice of law and malice of fact will come into
My lord,
play.
my lord, I have. My lord, kindly turn to page number 9 of my writ petition.
Page number 9.
Yes, ma'am. Grounds, ma'am.
Yes.
My lord. First ground I have said, my lord. The law says, my lord, that's all this judgment which is referred by the learned senior government advocate, my lord, additional. That has been dealt by the division bench judgment which I have placed. Where it says all this EA, Royapa case, SLF bus case, all judgments have been dealt. What is there? It says that whenever there is a policy and guidelines is there, it is whenever in violation of that policy guidelines, if you want to transfer somebody within 2 years, the requirement of the authority is to take into consideration that factor. You have to discuss. This is a requirement of law. Why this policy cannot be maintained? What is that exceptional circumstances and rare circumstances that prompted the authority to transfer them? Now, the law is settled. Law is saying that none considering this aspect, my lord, none considering this aspects amounts to arbitrariness. If you don't consider this aspect, my lord, otherwise what is this will have no meaning. Suppose you say, suppose 6 months within I am transferring you, and you are not referring to this particular guidelines, my lord. Then it says that it amounts to arbitrariness. The authority is required. Of course, this is not the enforceable right, but authority is bound, legitimately bound to consider why within such a short period, again, transfer has to be done. Your Honor, some exercise has to be done. And admittedly, in the affidavit, I will show, and no record has been brought in this court also by an extended affidavit. No exercise has been done. First point. Now, second ground. And that itself, the court is saying that that is arbitrariness, my lord. Because if you don't take the relevant factor into consideration, that is arbitrariness. Now, second ground. I have specifically mentioned because the impugn order is arbitrary, capricious, colorful exercise of it. The RTI reply dated unequivocally reveals that there is no office record, notings, no recorded reasons, and no approval from the competent authority in the official records pertaining to the transfer of the beneficiary. An administrative order of transfer passed in complete absence of any discernible administrative basis with the application of it since I have specifically taken matter because suppose anytime whenever an employee is transferred, first what I will do is to find out the relevant documents, how my transfer has been effected. How I will know what is working inside there with the competent authority, what factors prompted them to transfer me, how I will know. It's only through the official RTI. And the RTI was saying that no file is there, no noting, no recorded reason, no approval is there, nothing is, and in the affidavit also not disputed. Now, question comes now before this honorable court is that when there is nothing, my lord, now this oral submission is on the basis of what?
Yes,
Because it is the authority concerned will be exercising that mind, my lord, not the, now what we are doing here is to understand, is to find out only whether the authority has reasonably, properly exercised the mind or not. When there is no material which shows that how the authority has exercised the mind, my lord, then even how we can discuss that what prompted the reason that prompted
that is already mentioned in the impugn order, no. Right side,
order is
mentioned there.
Only public service.
No.
In the interest of
Vacancy,
vacancy, transfer is always done. It's only for against the vacancy only, my lord. How transfer can be done when there is already somebody sitting there, my lord? It is always done. Now, my lord, very interesting. Now, another point, my lord. Now, why it is not even public interest? Why I'm saying, my lord, from their affidavit, even I think they are admitted, my lord. Even after passing the order, I have not been released. I was not released for a long period of time. Of course, I also approached a bit late because I was pursuing with the authority concerned. They did not release me. That source was my presence there was required. My nature of duty was required at the present place of posting.
No, you cannot go. You cannot deviate from your argument.
No, my lord. That's just to show, my lord.
Your
Public
was required is not necessary in this
no,
argument.
public interest, my lord. Because what they are saying that public interest. Now, suppose public interest they are saying, for example, but of course there is nothing on the record to say that how this is public interest. It is always transfer is against the vacancy, my lord. Now, I was posted there. What is the immediate requirement, my lord? That I should have been released from my posting place. Then I would have been able to join a new place of posting. What the Supreme Apex Court is said, my lord, that pursuant to the transfer, an employee has to be released immediately. Then thereafter, he can join in a new place of posting. Now, my lord, if I am not released, my lord, which is there in the affidavit also, they have admitted, they have not released me. Now, if I am not released, how can I go and join in a new place of posting, my lord? First, I have to be released from my present posting of place by the competent authority, my lord. And no reliever was there. How can I just leave all the things and I can go without the approval of my superior
That
authority?
is like going in circles because you are saying no reliever, he's saying you are not vacating, so there's no reliever. That's like going round and round in circles.
No, my lord, this is one part of another ground. That reason, my lord, because one argument has been placed why I did not go and join the new place of posting. To rebut that argument, I'm saying that, my lord, because Apex Code has said that whenever a officer or any employee is transferred, it is his duty to go and join. Then you can file the case. But my case is what happened. I was not released by the authority. That's why I could not join to the new place of posting. Thereafter also, I could have always challenged the impugned transfer order. So this is basically the recent settled proposition of law in that way. So that's why I'm saying that, my lord, my not joining is not because of my own deliberate action. It is not because of the not releasing by the respondent authority. That's what I am trying to, my lord, put in that is. My lord, that part is given, my lord. Now, so far, this reason given my favorite choice, it is not there in the affidavit. It is made in the oral submission only. And I have no such instruction, my lord, since no record has been given to me. Nothing from the RTI even, my lord. It is not there. Now, even in the initial start of my argument, I said one of the order was modified. That was also transferred, but only that place of transfer and posting was modified, my lord.
Was suitable for you.
My lord, that part, my lord, that part, let's assume, my lord, for the sake of, let's assume, my lord, that even earlier posting transfer was done as per my choice. Let's assume it for the sake of. But the recent transfer, let's say that this is not even the case of frequent transfer. Let's assume for the sake of argument, my lord, that even for the present, let's assume this is the first transfer and posting. But the law says within 4 months, how you can do it. These should be exceptional and rare circumstances where you are violating the policy guidelines. You cannot just say that public interest. Then what is because every transfer will be a public interest, my lord. Every transfer and posting will be public interest. Every transfer and posting will be for the administrative agency. But what the law is saying that when a person is transferred, and within that policy is that at least expected that he has a legitimate expectation that 2 years he will remain. Now, if the employer is saying, no, we are not, we are transferring you within 4 months, 1 year, let's say even 1 year, or let's say 1 and 6 months even, then what the law is saying that you have to, employer has to consider why you are not allowing him to sit for 2 years. What is that special circumstance?
Okay, I get it. Let me dictate it and let me finally
my lord,
to a conclusion later. I'll
Repeating, my lord,
my lord,
repeating the same thing will not change the
may I take
No, let me dictate it.
my lord, may I take the affidavit, two line, affidavit of the government.
No, I'll go through the affidavit.
My lord,
While
sorry,
dictating, I'll
my
go
lord,
through
for
the
a short short, my lord, in paragraph, my lord, 13, page 37, my lord, we answered all the grounds given by the petitioner. It's wrong to say that we have not answered. My lord, paragraph 13, my lord, 1, 2, 3, we have given the reasons, my lord, the ground raised by the petitioner. Paragraph 13, page 37. Yes, 1, 2, 3. These are the ground raised by the petitioner and we answered accordingly. So it is not correct to say that we have not answered.
I think
My lord,
judgment.
my lord, one,
I hear you. I'll ask you again.
my lord, affidavit, my lord.
Well, otherwise, my lord, it will be difficult on the part of the government to take a consent to the employees before issuing a transfer. I'm sorry, my lord. That we, but what exactly the petition is asking for, my lord? What he's
You cannot deal so arbitrarily. Putting up a note without.
Nothing, my lord.
Man, approval, my lord, if your lordship see, my lord, he's the not only loan employee, my lord, 4 persons, my lord, 4 persons. It's a group transfer, my lord, not individual, my lord. I'm sorry, my lord, it's not individual, my lord. What the petition is taking, my lord, not consent, no reason.
No consent.
Where is the?
No, you said so.
Where is the law? Where say that when you are transferring 4 persons, you don't need to follow the procedure, my lord. This argument is.
Who said? Now you tell me under which law? Under which law you said that we have to take consent? Under what provision, my lord?
Consent not required.
Fundamental rules, my lord.
My lord.
What is required is, my lord, tomorrow they may say, my lord, you have to take consent. Now your lordship may kindly see, my lord, is there any by the intention or not? Yes, my lord. Whether the transparent order was in public interest or not. only these 2 points, my lord. Otherwise, my lord, everybody stand, my lord. No, this is my place of posting. Don't move it beyond 2 years, my lord. That will be difficult for state government to function, my lord. Right, my lord? Now, my lord, as I've already said, that petitioner belongs to my lord, SEPA, my lord, is coming this day. That is also against the my lord guidelines, my lord.
These all are mere
No,
oral
don't
submission,
forget
my
that.
lord.
Don't forget. Correct, my lord. No,
My lord,
no,
this all our submission is nothing on the record.
No,
It is not the, it is
this
the,
is legal point. What?
it is the
I don't, my lord, I'm sorry, my lord. For
authority
legal
has
point,
to,
my lord.
authority has to decide
No, no.
where the transfer has to be done, my lord.
I'm only
10,
concerned with the my lord, guidelines. Guidelines, my lord, for guidelines, I don't have to take any approval from anybody, my lord. These are legal issues, my lord. You cannot
This
deny
is
it, my
item
lord.
number 10, my lord.
Yes, item number
10, my lord. 10.
Yes.
I heard Learned Counsel Mr. Rajesh Khanna for the petitioner Hano Mangfi, who has filed his application under section, under article, no?
My
2 to 6, my lord.
Article 2 to 6 of the Constitution of India, praying for a writ in the nature of certiorari or mandamus or any other appropriate writ against the transfer order dated 15/9/2025 issued by the Principal Secretary, Public Works Department, Government of Arunachal Pradesh, Itanagar, the petitioner SH, the petitioner, you strike out that words, the petitioner, you write SH Hano Mangfi, within bracket the petitioner for short bracket close, is at present serving as, he was engineer or something, no?
Assistant engineer, my lord.
Assistant
Engineer.
Serving as assistant engineer at
Ipu subdivision.
Pipu
Subdivision.
subdivision,
PWD, my.
PWD. He was serving now. He's
Present posting
he's
place.
at, no, not present posting. Where is he serving?
Right now, the present posting place, my lord. Because this imping order has been stayed.
As assistant engineer.
Then you can't say that Pipu is your serving place. No, no, no.
East Kameng. Pipu, East Kameng district.
Pipu subdivision, correct. Not Pijarang, Pipu subdivision.
He is agreed by the order dated 9/9/2025, transferring him so he is transferred to Pijirang.
My lord, my.
Okay, but Pipu is transferred to Pijirang.
Pijirang, yes.
Pipu subdivision to Pijarang subdivision, my lord.
He is transferred from Pipu subdivision to Pijirang.
Pijarang subdivision, correct.
Against an existing
Vacancy.
It is submitted that the petitioner has been transferred for 4 times in 1 year. The first order, the petitioner has drawn the attention of this court towards the first order of transfer in the year 2024, which is marked as Annexure 2, the petitioner was transferred from A.E. Bameng PWD subdivision to
A.E. Balijan subdivision.
A.E. Balijan subdivision
Right.
on 15/10/2024. Next slide. From
Page 22, my
A.E.
lord.
Bameng subdivision to
ASW Sepa
ASW SEPA division
division.
on 15/1/2024.
25, my lord.
25. Next slide. After comma, next slide. From ASW SEPA PWD division to Pipu subdivision on 17/5/2025. This 15 is the last order, no?
My lord, imping order 59, my.
15. Any other order? Oh, yes, one more.
No more.
No, my lord.
Oh, no.
This is the last
59
is the last
annexure
order.
1.
Yes.
As the petitioner was being transferred to 4 different places within 4 months, comma, he applied for he made an RTI application, huh?
My lord.
RTI application, and the answer to his RTI application is marked as Annexure 4 of the petition, which clearly reveals that while the petitioner's transfer was considered, while the petitioner's transfers were considered, transfer orders were passed. While the petitioner's transfer orders were passed, the no, not the comma, no noting or correspondence was recorded or was to be found in the establishment. PWD, no?
My lord.
PWD. Full stop. No reasons or justification were recorded and maintained in the establishment. It is thereby contended by the petitioner that although transfer is incidental to service and is an exigency of service, comma, the transfer orders were passed in an arbitrary manner without recording any reasons or without following proper procedure by the department. Full stop. The policy guidelines clearly reveal that the policy guidelines of what is the policy, transfer policy?
My lord.
The name of the entire transfer policy.
My lord will find at page number 26, my lord. Typing copy, my lord, from page number 27. Is the guidelines for transfer and posting of all categories of officer and staff in Arunachal Pradesh, my lord. Page number 27, my lord, type copy.
The policy guidelines of transfer and posting of all categories of officer and staff. You noted somewhere that it is on page 27. Then you can write it correctly. Huh? But even then you take down my dictation. The policy guidelines and of transfer and posting of all categories of officer and staff in Arunachal Pradesh is approved by the governor. Indicates that a person can be transferred after 2 years of working in a particular place. Full stop. This is the legitimate expectation. It is the legitimate expectation of any employee that the authorities will follow the professed guidelines. Full stop. Non-consideration of the policy guidelines tantamounts to deliberate deviation of professed guidelines. Full stop. It is submitted that it is argued that if in any condition a person has to be transferred before completing 2 years, at least the reasons for transferring a person has to be recorded, and has to be recorded, and notes have to be put up for approval. and after proper approval, a person can be transferred. Full stop. Next para. It is averred that in the present case, the petitioner was transferred 4 times within 4 months.
Well, within a year.
Within a year. Okay. I have hiding already dictated somewhere
Within a year.
within a year, huh? Not 4 months. Transfer 4 times within a year. I have dictated 4 months somewhere. Of this act of the authority defines the principles of reasonableness and proportionality. It is, however, submitted that the act of the authority in transferring the petitioner randomly in such a manner may not be malice in fact, but it is apparent that such act is malice in law.
Right.
Or contra, learned government advocate.
I'm additional AG, my lord.
Additional AG, N.H. Nabam, no?
RS Nabam, my lord.
I don't know how that N came from. RS Nabam.
RS
Nabam. Laid stress in his argument that the transfer was on public interest. And the notification dated 5/15 notification transfer was on public interest, no?
Yes.
And the notification dated 9.
The transfer posting notification, my lord.
Transfer. Oh, 9/9/2025, no? Or 15/9.
Impugn order is 15/9.
On top, you lordship will find 9/9, but down below is 15/9.
The transfer order dated 9/9/2025 clearly reveals that the transfer order was passed owing to the existing vacancy in Pijirang subdivision. It is agreed that transfer and posting is, of course, incidental to service.
My lord, sorry for interrupt. I have said, my lord, he is one of the senior most, my lord, serving officer, and there being a vacant post, my lord, his expertise service is required there.
Okay, that last line you strike off. It is submitted that the petitioner was the senior most
assistant engineer, my lord, one of the
assistant engineer, and owing to the vacancy in the present post of in the
Pijirang subdivision,
Pijirang subdivision, the petitioner was transferred. It is further submitted that there is no embargo that an incumbent cannot be transferred frequently to sub rule 15 of the fundamental rules and subsidiary rules. Within bracket FRSR for short.
It should be rule 15, my lord.
15.15, no?
Yes, 1.5.
Deals with the rules on transfer and posting. Empowering the authority to transfer. So it is further submitted that unlike the submission of the you change the paragraph, no? And you number the paragraphs. It is further contended that unlike the submission of the learned counsel for the petitioner, that there were four continuous orders of transfer within a period of a year is not correct, as the order dated 15/10/2024 was never acted upon. Okay, this leaves us to 3 orders of transfer. Full stop. It is further submitted that the transfer order dated 15/1/2025 was modified, and the petitioner was posted to a place of his own convenience. Okay, I'm noting it down. Thus, there is no malice in law. Full stop. A senior officer is transferred to the same subdivision, no?
Same division, my lord. Subdivisions are different, but same division, my lord.
The senior officer is transferred to the same division for bona fide reasons. Full stop. It cannot be. It is the submission that no, Melapati was not. I think it's not submitted, no, from your side.
Malice, not malice in fact, malice in law. Malice in law.
Mela fide, my lord, because there is no private respondent, my lord, or to any particular. That's why, my lord, there is no any mala fide, my lord. Only mela is in law, my lord. That is something.
Well,
The
Pijarang, my lord.
PG?
It's a Pijarang, my lord.
Pijiran is only 13 kilometers away from.
Around, my lord. Around, I'm not that exactly.
no. How it can be 13? Pigeoning is
That's what I said. Around, my lord. I'm not sure about
no,
that.
my lord.
I said around 30
From
kilometers.
Sipa, people, because I also born and brought up there only.
And you'll be knowing better.
I know from Sipa, people, you have to go towards high area. It's like.
How far is it? 100 kilometers?
Pipu.
Huh? I don't think so. From Sepa. It will be around 30 to 40.
No, 30 to 50. No. It will be 70 or 80 something people.
But what is more important?
And
Within the
thereafter,
same division.
Pijiring is something, it's a completely other side of the Sepa. So this is North Pole and South Pole, something like that. It's not like 13 or 30 kilometers.
All right, my lord, kilometer, but it is the same division, my lord. Within the same division, my lord. Sepa division. Sepa division from Sepa. My lord, he has not been posted out from the same division. Only my lord, working place is different, my lord.
my lord, it's all.
Around means what?
So, my lord, exactly, I cannot
Not
say
below
also,
50
my lord.
kilometers.
Exact, I cannot say, but
Around 15 kilometers.
Around Bhubaneswar ho gaya.
From which place you say?
From Seppa's division. No,
Around 50 kilometers from Seppa.
Seppa it should be, no?
from Seppa, it should be then Pipu against Seppa, it will be 70 or something like.
No, we are considered with the division,
Seppa,
Seppa
Seppa,
division.
it will be like that.
Correct, Malad, Seppa.
Malad.
Then it's correct, Malad. Yeah.
Leonard, double AG, no? Double AG.
Double H, Malad. RS Novo, Malad.
No, I'll not forget your name, but
Double
double AG. Yes. Has relied on the decision of the Supreme Court in oh, so this is the books, no?
Books, Malad.
In 93.
Lordship first refer to Malad that is SC Malad section 2006.
Okay.
Wherein Supreme Court says, well, first you join the place of posting, then you ventilate before the court, Malad.
Okay. No, but I just dictated about public interest. So public interest is which judgment?
Malad that will be Malad SL.
No, I have not dictated.
Not dictated, Malad, no.
1993. That's the decision of the Supreme Court in SC Saxena versus Union of India and others reported in 2006 within brackets 9 SCC 583, wherein it has been held at which paragraph?
Paragraph 6 and 9, it should be Malad
6 and 9, okay. Paragraph 6.
Just make me
Nine is not required.
6 will suffice.
6, paragraph 6, huh? Relying on the decision of SC Saxena Supra, it is submitted that it was the bounden duty of the incumbent to first join his place of posting and thereafter to pursue his representation. But the petitioner has disobeyed the order of transfer and he has not joined his place of new posting. The learned counsel for the petitioner has submitted that the petitioner could not join his place of posting because the petitioner was not released.
Well, this is on their admitted affidavit also, they have admitted this fact.
Which has already been admitted by the through the affidavit submitted by the
Respondent authority.
respondent authorities. Authority or authorities?
Authorities, I think.
Authorities. Full stop. They submitted that the petitioner has not disobeyed disobeyed any order of transfer. Full stop. So this is not working then. This judgment is not working.
My lord, basically, my lord,
He was not released, then how will he join?
release, handing over, taking over, that is especially meant for my lord, those who have my lord, disbursement my lord, authorities, my lord. Those who are head of the division, my lord. He is not the head of the division, my lord. He is a assistant engineer. Had it been an executive engineer who has the power of disbursement, then I could have understood. Yes, proper release and all this is required. Because they have to clear the accounts, my lord. So that part I can understand. But here, my lord, petitioner is not the my lord, DD holder. He is just an assistant engineer. So may proper release order may not be required, my lord.
My lord, paragraph 8 of affidavit, my lord, government affidavit, para 8.
No,
Reason, my lord.
all
I'll
right,
just
but
read out.
legally I am submitting, my lord. All right, paragraph. Man, we are not disputing, my lord, as on that, my lord, he has not been released. We are not disputing that. And because of my lord reasons.
No, my lord.
It's correct.
My lord, para 8, my lord, kindly.
But they have admitted it.
Yeah, we have
My lord. My lord,
Release order is not required.
my lord, I have to first, my lord, release from the officer, my superior authority, my lord, because I am discharging duty. I have certain responsibility.
Sorry, my lord. Why I'm saying
Not
same division, my lord, because same division, my lord. Had it been different division, I could have understand. Yes, my lord. Within the same division, my lord, it's not required, my lord.
And my lord will see in the affidavit, I was retained there because of the exigency of the departmental works. They have written in the affidavit, my lord. I have been retained there because of the existence of the
It's
departmental.
okay. I'll not get into it.
Yes, affidavit
It
para
has been
8, my lord.
submitted and it has been dealt with. I'll not get into it further. It is further submitted by the learned AAG that additional AG you write, huh? Additional AG. That will be better. No, not only AAG, you write additional AG. That it has been held by the Supreme Court in that certain guidelines are to be followed. It has been held, not rather, you don't write it has been held, that certain guidelines are to be followed as laid down by the Supreme Court in Union of India and others versus SL Abbas, reported in within bracket 1993, bracket close for SCC 357, that
Six and seven, my lord.
para 6 and 7. By relying on the decision of SL Abbas, no?
Which was earlier one, my lord?
No, this one?
Yes, my lord, SL Abbas.
SL Abbas Supra, it is submitted there. There was no MELAP ID on the part of the respondent authorities, full stop, there was no violation of any statutory provision. And the transferring authority had every jurisdiction to transfer the petitioner to his present place of posting in the interest of public service.
Public.
Then you have relied on the judgment of public service
Yes, my lord.
of this court, no? The petitioner or the learned, the additional AG has relied on the decision of this court.
My lord, that is my lord, reason, my lord. If it is transfer and posting in public interest, then reason is not required, my lord. Paragraph 23 starts.
Public. Yes.
Public is a broader sense, my lord. Public interest.
This is why whenever we pass any order
My lord.
as authorities, not here, but as a district judge, we always write these 3 words in the interest of public service.
My lord. Now exactly, my lord, executives, they are following the same things, my lord. If nothing to be said, simply public interest. That will, my lord, accumulate everything, my lord. Public interest.
Because nobody has any malapide, but sometimes there is malapide.
Yes, my lord. If suppose some
That judgment he has referred to one Supreme Court judgment that one advocate, a lady, I think judge, I think was posted to transferred several times.
My lord, that's our own division bench has
Division
referred
bench.
all those judgments, my lord. All SLABs, everything has been taken into consideration.
Malafide, yes, but suppose if someone, my lord, incompetent officer is replacing me, then it's a clear cut of my lord, Malafide. Suppose rule says, my lord, that
This is not an actually happens in the.
happens, yes, my lord, happens.
Paragraph, which paragraph?
23, if I correctly remember, my lord. It starts with
4 in
20.
our Occam Siram versus State of Arunachal Pradesh, reported in 2023 within bracket 4 bracket close GLD 157, wherein it has been held that
Paragraph 23. इसी सेक्शन है लिखो एक्सी सवाना लगा
no. It is not held like that.
My lord, 3 issues, if I correctly remember, that were raised in that. The last issue was, my lord, that public interest reason. If your lordship see the issues, my lord, framed by the court, raised by the petitioner, my lord. Last issue was, my lord, that there was no any reason That was that was authored by Justice Surana, my lord.
Yes, yes. Okay, yes. Para 23, no? Para 23. Para 22 and para 23. Relying on the decision of R. upon Siram, it was held by, relying on the decision, it is submitted by the learned AG that in cases of public interest, no reasons are required to be no reasons for transfer is required. Are required. Reasons for transfer are required. In reply, the learned counsel for the petitioner laid stress in his argument that when the policy guidelines have been circumvented, the reasons are necessary to be the reasons are required to be shown.
I prefer the judgment division bench judgment.
The learned counsel for the petitioner is relied on reasons.
My lord, this is why when transfer and policy guidelines is not taken into consideration,
Which one?
my lord will find 2024 G for GLT 1, my lord.
The learned counsel for the petitioner has relied on the decision of this court in Dukan Kato versus State of Arunachal Pradesh and others.
My lord, yes, my lord.
2024 GLT 1.
My lord,
Wherein it has been held that
my lord will find from paragraph 11, my lord, and 12, my lord, where it says, my lord, that what's malice in law, and when this transfer policy guidelines not taken into consideration, no reason, then it is arbitrary, my lord. Para 11 and 12. And this, my lord, has referred this Registrar General High Court Madhya Pradesh, that judgment also, that malice in law, that has been referred in this. And this SL Abbas discussed, EY Royappa also discussed, and all discuss series of cases on this transfer policy, all case discussed in this case, my lord.
Para 11.
My lord, para 11, 12 will be most relevant, my lord.
11 and 12. Okay.
Yes, my lord.
Yes.
Then 21, 22 also, well, no proposal, 25, 27, those things are there.
21, 22, 25 and 27.
My lord, yes, my lord, 21, 22, 25, 27. They are also discussed, no
11, 12.
relevant 10, 11, 12, 21, 22, 25 and 27, my lord.
Para 11, 12.
10, 11, 12, 21,
11, 12, 10.
21, 22, 25 and 27.
21,
22, 25 and 27.
25 and 27.
It emphasized, my lord, that contemporary records justifying how transfer has been done, that has to be there, my lord. Here in the case, nothing is there. What authority did, we don't know anything, my lord.
relying on the decision of this of a revision bench of this court in Dukan Kato, it is submitted. After inserting the paragraphs, you type this. It is submitted that it is not sufficient to make an oral submission that that on account of a vacant post, a senior engineer was transferred. It is necessary to be recorded on what grounds the petitioner has been transferred, and the reasons have to be clarified. Why the petitioner has been transferred, as the petitioner has been prejudiced on being transferred 4 times in 1 year.
Then, my lord, 2 judgments for frequent transfer, my lord.
I'll just check if I insert this paragraph.
My lord.
11, 12.
My lord.
I may delete some paragraphs.
My lord.
I'll just check.
No issue.
So 25 is not required, I think. Paragraph 25.
Well,
It is basically related to education department. Paragraph 25.
my submission, here, this relevant, why I'm relying, this is because maybe guidelines, but why it is relevant? When, especially when a person is transferred within the completion of tenure. If it is after completion, the matter would be different, then.
All right, we'll include it.
My lord.
Relying on the decision, that I have already dictated, no?
My lord, if para 12 is para 12 and 27 is basically repetition, I think, my lord. If para 12 is considered, then 27, my lord, it's the same thing. 12 is.
Then you don't have to only para 10 up to para 25.
Yes.
27 is not required.
Not 12 if it is there, my lord, 27 not. Yes.
12 will be there, so 27 is not required.
You're not. Wait.
It is also submitted that. After all that, I have given one dictation, no? After including the para, then I have given one dictation, one line dictation. Yes, I have given, no? Yes. You continue from that line. It is also submitted that the petitioner was having a legitimate expectation to continue in his place of posting, although transfer policy may not be enforceable with law, but when such transfer policy has been framed, every officer will have a legitimate expectation when cases of transfer of officers are considered, full stop. After expectation, given insert one comma. When in the absence of any proposal, approval, or any reasons recorded, a transfer order appears to be arbitrary and suffers from malice in law. Okay. Now the question that falls for consideration is that whether the transfer order of the petitioner is liable to be set aside and quashed. Full stop. It is submitted at the bar. It is submitted that a transfer order on trivial grounds, if set aside, will open floodgates and will have cascading effect on the and will have a cascading effect. Full stop. So now what to do? That I cannot consider this judgment because he was transferred 5 times in 1 year.
My lord, your lordship may kindly note, my lord, if the petitioner is strictly harping on the transfer policy guidelines, he being an assistant engineer is a group A, my lord. As per these guidelines, he cannot be posted to his home district, my lord. That's why I've been trying to indicate, my friend, if you are living in a, my lord, glass house, don't throw a stone, is it?
Now I have been transferred not from the outside district, my lord. This justification will not be tenable. Why? Again, this transfer is also not something out of district, my lord. Now this present transfer also,
that's right.
It is within the same district only. My lord,
That's right.
my lord, that is not the ground and there is nowhere the reason also given in the affidavit also, my lord. Nothing is
Not
here.
necessary.
Now my lord will only see whether within a year, 4 times, without any reason, without disclosing any reason, authority can do it or not. That is only the thing my lord will examine.
2 times.
If we say, my lord, one, my lord, if we say modified, and it's a 3 times, my lord. It is on the record, my lord. There's nothing on the affidavit, my lord. That's why I'm saying, my lord, oral submission will not do, my lord.
No, but this is,
It has to come with the, my lord, affidavit, bringing on the record how my earlier transfer was effected, how it was done, my lord. Then only I will rebut, my lord. Only if all of a sudden while making oral submission, it's
No.
sufficient.
Oral submission based on what? The document adduced by you yourself, my lord. I have already relied on the transfer posting orders, my lord. We have placed 4 transfer posting orders, my lord. Out of 4, my lord, 1 is never acted upon, 1 is modified. You get the place of your own choice, my lord.
Otherwise also, my lord.
It's a part of record, my lord.
Even, my lord, if it is a first time transfer,
this is a part of
within a year, within a 4 months, even let's assume this is a first transfer. Is it the proposal making that within a 4 months, a person can be transferred without disclosing, without discussing this transfer policy guidelines, my lord?
in the wake of the program discussions, it appears that the petitioner has been transferred. The petitioner has been that the transfer orders have been issued. Transferring the petitioner within a year. 4 transfer orders have been issued to the petitioner within a year. It is true that the order dated 15/10/2024 may not have been acted upon, and the second order dated
1st January 2025, I think.
on 1st January 2025, 1/1/2025.
That was modified.
Modified to the convenience of the petitioner, but the fact still remains. So I will quash it.
Deeply obliged.
If your lordship interpret with the transfer order, then your lordship may allow us to pass a fresh transfer order in view of transfer posting guidelines, my lord. Because your lordship will be interpreting with, because my lord.
Again, you are going round and round.
My lord may be pleased to cause this. Thereafter, whatever let them do, they have a power, my lord. If they do something wrong, I will approach this honorable court, my lord. Authority doesn't mean, my lord, they can do anything.
Just a minute, because you have been harping that we have violated the transfer posting order. That is the cross ground, my lord, right, my lord? Then, my lord, your lordship may allow us to follow the, my lord, transfer posting, my lord, so that we can transfer him out from the district, my lord. That is also against the guidelines, my lord.
Then see how maliciously you are.
Yes, my lord. Yes, my lord has rightly pointed out.
That's why
let him exercise his own power.
That's why I have been saying, my lord.
My lord is there. We will approach this court. We will get the protection. Let the responding authority do whatever.
Is there any mala fide intention beside mala guidelines? None, my lord.
Let him do whatever he wants.
No. My lord, what he is saying, my lord, we have not complied with the guidelines. That's a mala fide. Is there any other ground beside the transport posting guidelines? If your lordship finds, then your lordship may interfere with. Otherwise, my lord, it is not required. Number 2, my lord, is within my hometown, within the same division. Where is the hardship, my lord? There is no any hardship, my lord.
It is a fact that the petitioner has been transferred.
Within the same division.
Transferred twice twice within transferred twice within 1 year. Petitioner has it. The fact remains that the petitioner has been transferred twice. If that last line, no. If the you strike it, strike that it is a fact, you record like if the third or if the second place of posting was to according to the convenience of the petitioner, then 2 transfer orders have also then 2 transfer orders remain which have prejudiced the petitioner. Full stop. The petitioner then we are left with not 2 transfer orders. Then we are left with 2 transfer orders, which according to the petitioner has prejudiced him. Full stop. The petitioner 2 transfer orders within a year may appear to be arbitrarily, more so after circumventing the guidelines of transfer policy of the state. Full stop.
And my lord, without there is any discernible reason on the record to justify transfer. Without there being any discernible reason, my lord, to justify that transfer even.
My lord, the reason is not required. If it is in public interest, I have given the law, my lord. I have given the law, my lord. Not required, my lord. Reason is not.
So that order
Finishing part, your lordship may, my lord, dictate later on, my lord.
yes.
My lord.
Order dated so is set 15/9/2000. Transfer order dated
15/9/2025
is set aside and quashed. Then this is not required. Set aside and quashed. So he doesn't want promotion. What to do?
I'm sorry, my lord.
He doesn't want promotion.
No, it's not question of promotion, my lord. What my
It's a type of promotion only from sending from the center to the subdivision to operate, function the area alone. Heading the area.
no, my lord. From Dipu to my lord, this
He'll be heading.
both are subdivisions, my lord.
Okay.
From subdivision to subdivision, he was transferred, my lord.
Well, it is
Not from division to subdivision, my
It is
lord.
something, my lord. People,
So not an upgradation.
No, that is same, my lord. Sir. Not upgradation.
hilly area, where I am being for a plain area. I am fond of hilly area. That's why, my lord. That's why, my lord.
My lord, Arunachal, I'm sorry, my lord. Arunachal is a hilly area. It's not like Assam, my lord. If you don't want to work in hilly, then you should. My lord.
There is hilly area, my lord. This Dimasa area and
Very
Pokong area.
very
I have been there, my lord.
comparison to Arunachal Pradesh. I'm sorry, my lord. We have the highest. peak, my lord. That part your lordship may kindly consider.
So I think I'll be able to take up only one matter. Yes, you come. No, not you.
Pass over matter, item number 2.
You.
My lord, item
There's a
number 2, my
mistake. You want to just you want to correct one, modify one order?
My lord, there is in court number 5, my lord.
Okay.
There is not listed here, my lord. There is listed in, yes.
Okay.
Yes, my lord. Hello.
So first matter.
Yes, madam.
because, He's in the jail.
Yes, my lord.
And I think suffering from some ailment also.
Yes, my lord, yes.
You got it modified.
No, my lord, it's listed today, but the item is not right yet. Yes, my lord.
It's really worrisome because he's ailing, he's in jail, and he's really worrisome. Whenever I see you, I get worried.
Yes, my lord.
Pass over matter, item number 2.
Item number 2, I'm getting, my lord.
In the book. 2 judgments are in the book. 2 books. Yes, item number. Just can you raise it? Somebody.
Yes, sure.
Item number 2, my lord.
Yes.
I am appearing my item number 2, my lord.
Item number 2. Yes.
Yes. My lord,
I have been compulsorily retired, my lord.
Can you-
Kindly come to page 20 of
This is admission.
page 20 of the
Ma'am, is this okay?
motion, my
Is
lord.
this motion? You want to stay?
Ma'am,
You want to stay?
No, my lord, I want only a notice, my lord. I want
Only a
only a
notice.
notice, my lord.
Okay. Can we issue notice? Yes.
Lordship, Lordship may Paris last order dated 19/3/2026, Your Lordship. As per there was a judicial order because the petitioner was supposed to satisfy the court on delay and laches, Your Lordship. There has been delay in filing this writ petition, Your Lordship, regarding the maintainability of this writ petition. So that has to be heard first, Your Lordship. Regarding the maintainability.
I am ready with my
19/3/2026, Your Lordship.
Yes, what do you want to say?
My lord, I'll make my submissions, my lord. I'll satisfy lordship, my lord. On the last occasion when the matter came up, a question was raised on delay and laches for 4 years. Then we made a submission that when there are certain conditions where a writ petition cannot be thrown away on the ground of delay and laches. And then on that day we argued that when delay and laches, the grounds of delay and laches cannot be raised in case where there is a continuing cause of action. If the cause of action is continuing, then the writ petition cannot be dismissed on the ground of delay and laches. Secondly, my lord, there are 4 grounds, my lord, we had we want to argue, my lord. When no third party interest is involved, or if the reopening of the issue would not affect the settled rights of third party, in that case also the ground of delay and laches cannot be taken. Thirdly, my lord, when there is reasonable explanation for delay by the petitioner. And fourthly, when the petitioner approves for enforcement of his fundamental rights under Article 14 and 21. In that case also, my lord, delay and laches, grounds of delay and laches, my lord, will not come. Now, my lord, I'll take your lordship to the judgments. I have a compilation. My junior will hand over. Before that, kindly come to page 20 for a moment, my lord. The impugn order, page 20 of the writ petition.
There was
May I
a delay
read, my
of
lord?
4 years, huh?
Yes, yes. Page 20 of the writ petition, my lord.
Yes.
My lord, this is order dated. This is order dated 27 September 2022. Read, my lord, in exercise of power conferred by FR 56J1 and having considered the recommendation of the review committee, I hereby order for compulsory retirement of Sri Taket Jarang, Deputy Secretary cum Deputy Controller of Examination under suspension on the ground of lack of integrity and ineffectiveness with effect from 27/9/2022. So, my lord, here the rule which have been invoked is rule FR 56J1. While invoking the rule 56J1, they have used two words, my lord. Lack of integrity being one and ineffectiveness. Now 56, I'll take your lordship to 56. Let us take up 56J1 for a moment, my lord. 56J1.
Sorry.
FR 56J. It is under chapter 9.
He doesn't have to take the. You bring it back.
Yes, he is going to bring.
I'll read 56A, my lord.
Yes.
Notwithstanding anything contained in this rule, the appropriate authorities shall, if it is of the opinion that it is in the public interest so to do, have the absolute right to retire a government servant by giving him notice of less than 3 months in writing or 3 months pay, an allowance in lieu of such notice. If he is a Group A or Group B service or post in a substantive, quasi-permanent or temporary capacity and had entered government service before attaining the age of 35 years, after he has attained the age of 50 years. Now, my lord, this is 56J and 1 which I have read. In the entire rule, the only criteria, the only ground mentioned is in public interest. Had they passed this order of compulsory retirement stating that it is in the public interest that I have to be compulsory retired, my lord, then it would not have been a stigmatic order and it would have been innocuous order. Now, specifically mentioned that lack of integrity and ineffectiveness, these two words are there. So when these two words come, lack of integrity and ineffectiveness, then this order immediately becomes stigmatic. My lord, the ground of delay, we will place the compilation. We have filed, my lord. I'll ask my junior to kindly hand over.
I've got it.
And my lord, what articles have been violated, my lord? Article 311(2) is violated, my lord. 311(2), no opportunity was given to him. Immediately after his arrest, this order was passed. He was, my lord, arrest impugn order, my lord, is 27/9, and he was arrested, my lord, just few days before. Put date to there. I'll give the date, my lord. Now, my lord, of the compilation, my lord, on I have pleaded 4 grounds where delay and laches cannot be taken as a reason for dismissing the writ petition. Ground A, delay and laches cannot be raised in a case of continuing cause of action. For that, I will be submitting the judgment of Vidya Devi versus State of Himachal Pradesh, my lord, 2022 SCC 569.
Okay.
Compilation page 8 and 9, my lord. 8 and 9 of the compilation.
Yes,
Serial
I got
number
it.
8 and 9 of the. I am reading 12.12. Lordship have found it. 12.12.
Yes, 12.12.
Yes, I'll read. The contention advanced by the state of delay and laches of the appellant in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of a continuing cause of action or if the circumstances shook the judicial conscience of the court. Condonation of delay is a matter of judicial discretion, which must be exercised judiciously and reasonably in the facts and circumstances of a case. It will depend upon the breach of.
Just a moment. We have, which respondent do we have before us? Government?
Lordship, I'm for 2, 3, and 4, your lordship, for Public Service Commission.
Public Service Commission. And anybody else? 1, respondent number 1.
I'm hearing on behalf of Standing Council for Education. In fact, there is no avertment, allegation against the UVP.
Okay, let us issue notice. We'll keep the issue on maintainability on delay and that's just open.
Lordship.
Yes.
Lordship.
Okay.
Lordship.
That can be done, madam.
Whoever Learned Counsel, it has to be heard properly.
Yes, my lord.
Learned Counsel, Mr.
F.
Your
Khan.
name? F. Khan is present, petitioner, and Learned. Yoko 1.
Yes.
Counsel, Mr.
Arkoyu on behalf of
Arkoyu is present on behalf of Learned Counsel, Mr.
T. Tagum, Standing Council.
T. Tagum, Standing Counsel for Education Department, and Learned Government Advocate, Mr. Y. Rira is present for respondent number 2, 3, and
No, Your Worship. 5, 6, 7, and 8.
5, 6, 7,
And 8.
and 8.
Yes.
Full stop. Issue notice to the respondent number 2, 3, and 4.
Lordship, I'm for 2, 3, and 4, your lordship.
Okay.
I'm for respondent number 2, 3, and 4.
Okay, Learned Government Counsel, Miss.
Standing Counsel N. Anju.
Learned Standing Counsel, Miss N. Anju is present for respondent number
2, 3, and 4.
2, 3, and 4. Full stop. Issue notice. Will not issue rule. Will only issue notice.
Lordship.
Okay. Issue notice to the All respondents are here, but let us issue notice. Issue notice to the respondents, leaving the issue on maintainability open. Okay.
Lordship. Lordship,
Then it is
extra
on the
copy, your
ground of
lordship.
Extra copies to be furnished to the respondents. Please stop. List on, when do you want in the admission column? List on.
Lordship, after summer break, your lordship.
After summer,
break any day,
after
madam.
Lordship.
Date may be
issue
fixed,
note-
kindly, my lord. Date may be fixed after summer break, any date, my lord.
We will say keeping the issue on maintainability on delay and lectures open.
Open,
Huh?
yes. Yes. And a date
So
kindly, my lord.
extra copies to be furnished. List on, please fix a date of application.
20 July.
20 July. I'm telling this back to your senior, or should I keep it in the record? This compilation.
My lord, this may be kept in record as X.
Okay.
As annexer X.
Okay. Compilation has been submitted by. Compilation is submitted or has been submitted on behalf of the petitioner, which is marked as X and kept in the record.
Yes.
Okay.
I'm grateful, my lord.
Obliged.
Item number 11 to 14.
May I please, Your Lordship? In item 11 to 14, my lord, I am appearing for the respondent number 1, 2, and 3 in writ
11.
petition.
13, 14. Okay.
I am appearing for respondent 1, 2, and 3 in writ petition 63/2026.
This is for admission, no?
Yes, ma'am.
Okay.
We need 1 week time to file our affidavit,
Okay.
my lord.
Learned Council, Mr.
T nega.
T.
Nega.
11, 13 and 14. No?
Lordship 11 and 13. I'm appearing for 3 to 8. Respondent number 3 to 8.
Okay. Learned Council, Mr.
Cool.
T. Nega is
3 to 8.
present
Cool.
for the petitioner. Learned Council, Mr.
HK Nath, my lord.
H.K. Nath is present for.
I am for 1, 2, and 3 in writ petition 63 and 1 and 2 in writ petition 97 and 118. There are 3 writ petitions.
So we'll pass an order separately then.
Yes, ma'am.
So you are in now, we are dealing with which
Writ petition, item number 11 is my lord, writ petition 118. In there, I am appearing for 1 and 2.
H.K. Nath is present for
Respondent 1 and 2.
respondent number 1 and 2.
I'm for 3 to 8.
Learned Council, Miss, your name?
SK.
SK is present for respondent number 3 to
8.
8. Learned Council, Mr.
लिख लो पेपर
P.
में।
Nath is present for
Respondent number 10.
respondent number 10.
For respondent number 9, I think number 11. 9 is the BCCI.
Yeah, okay. Learned Council, your name? R. Thakur is present for respondent number 9. We are dealing with only item number 11 now. To stop the time has been sought to file objection.
Affidavit in opposition.
Affidavit in opposition by the respondent number
1, 2, and 3.
by the
Sorry, 1 and 2, my lord.
on behalf of respondent number 1, 2, and 3.
3 to 8 also, Lordship.
Okay. Adjournment has been sought to file affidavit in opposition by the respondents. List this matter on.
Can it be on 29th, my lord?
It depends upon you. Everybody is agreeing that
Yes, ma'am.
it's on 29. 29, okay. Item number 12 or 2000, Learned Council, Mr. Yes.
We have some.
Learned Council, Mr.
In item 12, I am appearing for HK Nath 1, 2, and 3.
T. Lega is present for the petitioner. Learned Council, Mr. H.K. Nath is present for respondent number 1, 2, and 3.
Yes.
We are not appearing in 12.
Okay. List this matter as time has been sought to file affidavit in opposition. List this matter on 29. Then
And item 13 is I am for
Lordship,
1.
in item number 11, the interim that was passed, maybe continue.
item number 11, just like interim order shall remain in force till then.
Yeah.
Item number 11. Okay.
Item 13, 1 and 2.
Learned Council, Mr. T. Nega is present for the petitioner, and Learned Council, Mr. H.K. Das is present for respondent number 1 and 2. Not appearing.
3 to 8.
And Learned Council, Ms.
SK.
S.K. is present for respondent number 3 to 8, and Learned Council,
P.
Mr. P. Neog is
For
present
13.
for
97 maybe.
Respondent number 10. Learned Counsel Miss R. Thakur is present for respondent number 9. Gustav. Adjournment has been sought by the respondents to file affidavit in opposition. You have any interim order?
Yes.
Interim order shall remain in force till the next date of listing. This is the matter on 29/6. Okay.
Yes, item number 14, Lordship, there is a technical defects. So we'd like to withdraw this IA to file afresh with liberty.
Council Minister J. Jini is present.
Item number 14. 103, IA 103 of 2026.
IA number 103 for the applicant and has prayed to withdraw this application as some technical defect has to be rectified. To stop. Opposite parties are present here.
Yes, ma'am. 1 and 2, madam.
Learned Counsel Mr. H.K. Nam
Madam.
is present for respondent number 1 and 2, and Learned Counsel Ms. P. Tapu. I am also for BCCI. Is present for BCCI. Petition heard both sides. Petition is dismissed on withdrawal with the liberty to file a fresh application. Okay. Item number 12. 63. I am for respondent number 12. Okay, 12. Item number 63. 12, no? Learned Counsel Ms. P. Tapu is present for BCCI. All right.
Item number 15.
Tell this Sofa to give me water. Pani chahiye, no? So this party is not present this side.
Petitioner.
Respondents have appeared. We'll fix it for admission. Pleadings are complete.
Pleading.
Petitioner is not represented today. Government advocate, no?
Since contempt, so I'm appearing on behalf of respondent number 1, Lord.
Learned Counsel Mr. S. Tapin is present for respondent number 1, not government advocate.
Contempt is
Private party.
Yeah.
Learned Counsel Mr.
N. Norbu. For respondent number 2, N. Norbu.
Who? On behalf of somebody?
Respondent number 2, Shri A.K. Singh.
But your name is not in the list.
I filed my wakalatnama.
Is present for respondent number 2 and has submitted that and wakalatnama has already been filed for respondent number 2 on by respondent number 2, no?
Yes.
Not by respondent number 2. Then when you should I list this matter as readings are complete, we have only 2 respondents here.
Yes. No,
Three.
more.
There's one more. One more. 3 respondents.
They have all appeared.
I think that they have not yet appeared.
Okay. Readings are not complete, no? Let me see. To increase respondent, okay. They have been increased later. Respondent number 6, wakalatnama has been filed. Respondent number 5 and 6. Wakalatnama has been.
No.
3, 4, and 5 are yet to appear, I think.
So
6 wakalatnama, respondent number 6 has filed wakalatnama.
But four losses already appear.
You will appear.
Because 4 and 2 losses.
Yes, stopping respondent number 1 and 4 liquidate. So we have then we'll issue notice to the other respondents.
Notice was already issued. Yeah.
Or then
Whether the petitioner has taken is safe or not. Petitioner only.
I think they have taken steps. So 2 and 3, no? Only 2 and 3. Oh,
No.
You are appearing.
I'm appearing for respondent number 2.
3 passed away, died.
3 and 5 are
3 and 5, okay. Service report on respondent number 3 and 5 is awaited. I think 3, most accept been taken, I think. I can see only 4, 5, and 6.
Let's let the matter come up tomorrow. Petitioner will come up and they will.
They have taken steps. Service report on respondent number 3 and 5 is awaited then.
Let them take place instead.
Long time back they have
Long
taken.
time back.
Petitioner may take fresh steps to issue notice to the respondent number 3
and 5.
What about you are appearing for 4?
Yes.
6 as file vocalat number 3 and 5. List after the summer vacation.
Close.
Item number 16 and 17.
That's right.
Lordship, this IA is for, we are seeking implement of the applicant as respondent in the WPC 228 of 2025.
Do you have any objection?
Yes, I have filed an objection. So
Today, it was
today not be possible, my lord. So may it be fixed in the next week or after 2 weeks?
Do you feel positive of time list this matter?
Yes,
After?
a week.
2 weeks.
After 1 week?
Yes, 1 week.
Item number 18.
Of like
Mission.
Lordship, this matter, I have a small prayer to make, Lordship. Since it is listed for orders, in fact, but then I have a small prayer, Lordship. This matter was filed in the year 2025, in the month of October, Lordship. It's been almost 9 months. The respondent cites one small instruction they had to sort from the Deputy Commissioner. The compensation amount that was determined in my favor, Lordship. I am the beneficiaries. That was withheld on the basis of a representation submitted by private respondent 5 to 12. Now, in these writ petitions, without any reason, that reason why that compensation one was withheld, that instruction was to be sought from the Deputy Commissioner that they are taking 9 months, Lordship.
Your Lordship,
time after time, they are seeking time to take a small instruction from the Deputy Commissioner.
we
I fail to
received,
understand, Lordship.
The Parawise comment earlier, Your Lordship. We received the Parawise comment earlier, Your Lordship, but it was not clear. That's why we sent it. Yes.
Lordship, that clear instruction will never come. Why? Because they don't have any reason to withhold my compensation amount, Lordship. That entire process was complied. Now, on the verge of dispersing that amount, this private respondent 5 to 12, they came up with a representation.
Now, you should notice to all the others.
Yeah, they are appearing, Lordship. 5 to 11, 6 to 11, 6 to 12, they are appearing. And respondent number 5, we have taken dusty service. In fact, to that effect, we have filed one affidavit also.
So, make the pleadings complete and listed for admission.
Since they are not filing any affidavits,
Your Lordship,
Lordship, may I pray that this matter may be listed for admission hearing?
one last chance.
Last chance, that may be recorded in the order sheet, Lordship. Otherwise, they keep on taking time.
Only you have to, you want.
And my client are pressing really hard, Lordship. Just to take one full instruction, 9 months, Lordship. Are pressing really hard, Lordship. No, Lordship, compensation amount.
Land compensation.
Land compensation. Entire process was complied as per law. Just on the basis of a representation, my compensation amount was withheld.
So, Mr. JG is present for the petitioner and petitioner, no?
Petitioners.
Government advocate, Mr. Y. Ridam is present for respondent number 1,
2 and 3.
2 and 3. Whose notices have been served to respondent number?
6 to 12. They are in fact appearing, Lordship.
You said no? some one respondent was to appear.
Dusty service to respondent number 5.
Submit sir, justice to respondent number 5 and affidavit relating to service of notice to Dusty Mode has been filed. There's affidavit.
Lordship, it should be in the record, Lordship. I don't remember the exact date, but we have, it's part of the record.
Full stop. No. Service report on the respondent number 6 to 12 is still awaited.
No, Lordship. In fact,
They have appeared.
in the previous order, they have appeared. Mr. Sunil Mao
Respondent number
is appearing.
6 to 12 is have also appeared, but they are not represented today. Have entered appearance, sir.
Last time also they have not appeared.
They have not, but they are not represented today.
Today they were there, of course. They were there till last, but then I think they,
Appearance. That is sufficient. So we have only 4 and 5.
5 we have taken Dusty service, Lordship. Today effect 4 CGC has to appear. Last time also that order was in fact today effect or one order was passed saying that CGC has to appear, but I don't know why he is not interested in appearing, Lordship. Union of India, normally Union of India is represented by CGC. I'll inform him.
I don't know. Seen the affidavit relating to Dusty service of office. The number.
Right.
Same is placed on record, but I cannot find it on record. It's placed on record separately. Oh, here we have filing. Maybe it's a file separately, no? The separate file is the separate file. In the affidavit relating to Dusty service of notice on respondent number 5.
In fact, this respondent number 5 is a practicing lawyer, advocate, I'm told. Yes, I'm told he's practicing it. Okay.
Signature has been the signature has been affixed on the notice. A last opportunity is accorded to the government of Arunachal Pradesh, government, no?
Yes, of course.
File their affidavit in opposition. And no further chance will be, opportunity will be allowed. Is this matter after vacation?
Lordship, can it be on 29? I have one more matter, Lordship. They had to take one instruction, telephonic instruction also they can take, Lordship. That simple instruction, why that compensation amount was withheld. That's all, Lordship. So reason of withholding, maybe reason being the representation that was filed by respondent number 5 to 11. Then if they say that is the reason.
Therefore, announcement of compensation.
Lordship, that notification, everything was complied as per 2013 Act. Everything was complied. And beneficiary list was in beneficiary list, my name was there, Lordship. The amount was to be dispersed. At that point of time, respondent number 5 to 11, they filed one, 12, they filed one representation. So on the basis of representation, my compensation amount was withheld. That is illegal, actually.
Right. What?
No, one matter is there.
But I will not take it up.
Item number 25.
Obliged, Lordship.
For 25 and 26, I won't.
No, only 25. 26 is already adjourned, only 25.
Okay.
Item number 25.
I can take it up. Orders matter, I can take it up. Doctor has been served.
Sir, but still awaited.
Okay, service report on response. Service
1 to 4.
On which respondent?
1 to 4.
1 to 4 is awaited. List after 4 weeks.
Yes. Your Lordship, there is an interim, it may be continued.
Okay, no? Matters
Yes,
are over.
yes, matter is over.